It's time for Friday Night Live. Welcome, Law Nerds. We have a packed, packed evening. And I realized my ring is still on the charger. Well, boo. I was like, my hand feels naked. Yep, still on the charger. Oh, well, that's what happens when you wear, devices literally everywhere, all the places. Tonight, we are talking about the weekly roundup real quick, and then we're going to talk about what's going on with Wendy Williams' Instagram video and kind of what's going on with that case as best we can. TikTok getting sued, Megan Thee Stallion getting sued, and we're going to start getting into Johnny Depp and Amber Heard. Warning, there are chat rules. So for those of you that are live and those of you that watch in the replay crew, love you. There will be timestamps down below. I know that these are polarizing individuals. I know that. I cover the court documents. So I am not going to be covering everything that has gone on surrounding the court documents unless it is relevant to the documents we're talking about. That video is coming tonight. There's some very specific documents that we're talking about, but there is an episode of the Emily Show that is going to do a breakdown of all. That takes a little while to put together, but that is coming before this case goes to trial in April. So just know tonight is not the night, and I am not the one. Tonight, we're talking about what happened in court this week, what the latest motions are, what the court ruled, and the implications of that, just to set the expectations a little bit. We have a bunch of stuff in the weekly roundup, and we were tight on time a little bit based on an appointment I had on Tuesday. So I'm going to try to leave space for questions this evening, because I love getting to chat with the law nerds. And with that, let me know where you're coming in from. Tonight is a stay hydrated, mind my business type of an evening. We are all agua this evening because that is what I need. I do. It's been a busy day and I've been on calls and stuff and I am just not well hydrated. So tonight we are hydrating. It is time. We should just get started. Does that sound like a full show to you? The mods are already like, girl, that's a lot. Don't worry. The roundups are roundups. We're going to round them up and move them out. We're going to, something like that. Round them up, move them up, herd them out. I don't know. We should just start.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
It's so good to see everybody. It's good to see the mods. It's good to see you all coming in. It's good to see everybody. Tonight's a night. I don't know how your week's been, law nerds, but my week has been a little bit wild. It's been a week. Like you saw me on the sass It's good to see you, Brandis. You've seen me on the sass on Tuesday. Tuesday was very sassy. Today I'm just like, today is we're just a little tired. It's been a busy week. There's been a lot in the law going on this week, but I also want to share something else that happened this week. I did a thing. It always feels weird to say that. I should have stream of consciousness. Emily, have you pulled up the thing that you're going to show? No, I sure haven't pulled up the thing I'm going to talk about. Nope. Sure should. Sure didn't. Sure gonna do it right now. But I did a thing, and there's a reason I did a thing, and I wanted to tell you about that. I started the Quick Bits channel. I talked about this a little bit on Tuesday that I was gonna do it, and I was like, I'm gonna do it. We're going to do it. So I'm going to show you real quick where to find that if you are so inclined, because you like the quick updates. Here's the thing. The quick updates audience and the live stream audience are two different audiences in the minds of the YouTubes. So for that, if you go to my channel, hi, it's my channel. Look, we're live. If you go to channels, you will see it here and you will be able to go over to Quick Bits. My reels, I want to call them reels. my YouTube shorts that are reels will be here on this channel. And then I will be doing the clipping down of some of the stories in the live stream. So if we have a 3-hour live stream and I can clip down a 15-minute segment on a topic that I'm covering a lot, I will put those over on Quick Bits for those of you and those who find that channel who are just like, I don't even want a timestamp like that. I just, what, could we just do the thing? I plan to do more and more of the 1-minute shorts or several 1-minute shorts because as things happen quickly, I want to be able to get you the information kind of with what happened because the headlines don't always get it right. And I'm going to be traveling a lot coming up. So our stream schedule might get a little funky as I'm traveling, but I want to make sure that I am still able to provide what is going on in court and those quick bits. So that is why they are over there, to be fully YouTube transparent. The YouTubes don't really love a long form channel also having short form content on it. I love keeping you up to date in that way, but I figured this was a cleaner way. So for those of you that are like, yeah, I don't need the 1-minute shorts, perfectly fine. But if you're like, I want both, there we go. That's where they're going to be. So all of the shorts from now on will be on that channel, and I will share them out in the community tab on this channel if you want to go watch them. So that's what's going to be happening with the quick bits. I decided it would me and ADHD, me going, I have an idea, execute it immediately before it runs away. Hey, I should do this. Great, done. That's the way it has to be in my world. If I have a thought and I don't execute it immediately, the thought will leave. I will move on to something else. I'll get distracted and decide I need to become like a bonsai tree artist or some shit, and it will never happen. So I tend to move quickly on things, which is why I'm always amazed when I see people like teasing out drops of stuff when I'm just like, oh, I had an idea. Look, now we have shirts. It'll all happen within like a 12-hour span. Immediate execution, or I will possibly move on and lose interest. It's just the truth. It's just the truth. So that'll be linked down below. That's linked on the channel if that's something that you are interested in. It's there. If you are in the text crew, I will share those out occasionally there. And yes, there is the ASMR channel is going to get rebooted. I've been very busy and hadn't had time, but there I owe you guys like a list of videos, and it's not really ASMR. It is soft spoken readings of legal and historical documents. So if you're here for the non-cursy soft spoken documents, the thing I liked about that is I also learn better through hearing. So when I'm going through the documents, I'm trying to do it as a resource for not just those of us that are neurodivergent, but for those who are like, I just need something soothing and I don't need Emily to all of a sudden be like, wait, what the fuck? Right. So that lives there. I've been friends with Peter Mon enough that I'm now like, just start a new channel. It's going to be fine. So that is what is going on with me and with us. Yes, the Bill of Rights is coming, Jakes. It is. The Bill of Rights is coming next. I have been needing to do the Bill of Rights for like, I don't know, a year. The Bill of Rights, I want to do the Reynolds pamphlet. I'll do some of the founding documents. I really enjoyed going through the Federalist, Anti-Federalist papers. It takes me time because I need to mark up the document for pacing because it's not written in the way my brain works. Like the languaging and the pacing of the languaging is so very much not the same in the way it was written then and the way it's written now. So it does take me a little bit of time to go through those. That is not an excuse. It's just I get tailed into these cases and I'm just like, away we go. And off. And off. Also, letting you know, we are just about to bing at 201,000 subs here on the YouTube. So you're welcome to sub if you have not done that. I don't ask in nearly enough of my videos to do the likey and subscribey things, but it is creative mixed media art. this comment caught my eye, and then I'm going to move us into what we're doing for this evening. I have 8 crafts going right now. Someone on social media, I don't know if it was a TikTok. I follow a lot of ADHD specific accounts because I learn more about me, and they tend to be humorous. So I don't know if it was TikTok or Instagram, but it was an ADHD account that was talking about doing like an ADHD hobby swap where you could be like, look, I got really into, I don't know, coloring or into, jewelry making or, organization or bonsai tree artistry or whatever it is. And then I completely lost interest. So here is my vinyl cutting machine because I thought that was my love language for a bit there. And now I've completely moved on, where you can just swap everything that you've bought for the hobby that you subsequently lost interest in. And I was like, oh my God, that's brilliant. That's brilliant, because the amount of stuff over the years that I have gone through is particularly incredible. So it's just a brilliant idea. I'm like, there's a period of time where a lot of us are like, I should get into needlepoint. And then you're like, thank you. It was Catasaurus on TikTok. It's a brilliant idea. The problem is all the people who love it are so ADHD that none of us would ever facilitate it. We need to bring in the non-ADHD people to facilitate this for happening, because I think it's great. So that diatribe and digression aside, what we are going to get into with I'm just going to give you what's coming up for the quick bits the weekly roundup, because it's Friday. So for our weekly roundup, we are going to talk about the Duggar sentencing delay. What's going on in the Jen Shah trial, the USC college admissions scandal, water polo coach trial, the Vanderbilt RN trial, because a verdict came down today. I'm going to talk about that briefly. And Wendy Williams with what came out in her Instagram video. Those are kind of what we're looking at for our roundup. Before we get to our weekly roundup, I do have to thank the sponsor for this stream, because I love our stream sponsors. They take care of me. I've been working with this sponsor for over a year now, and I am so happy to bring you another video sponsored by NordVPN. A huge thank you to today's sponsor, NordVPN. I've been working with NordVPN for over a year now. It's the VPN I use on all of my devices. And when I say all, Nord allows you to use their VPN on up to 6 devices. So your phone, your iPad, the kid's iPad, laptop, whatever it is, you can put NordVPN on it. I put that shit on everything. What is NordVPN? If you are new and have not heard me talk about Nord is a virtual private network that encrypts your data as it travels across the interwebs. Nord uses a super fast encryption so that it doesn't slow down your web browsing, but it protects your data. If you are getting back out into the world and starting to travel and are going to use sketchy hotel Wi-Fi, or God forbid, Wi-Fi at the airport, you have to have a VPN on so that your data is protected, your information is protected, and your passwords are protected. Look, people lurk for all of your private information on the internet. You might as well lock it down the best you can, which is why I trust NordVPN. Not only do you get an exclusive deal with my link down below at nordvpn.com/EmilyDBaker, but you also have a risk-free 30-day money-back guarantee. There is no reason not to try Nord. See how easy it is to connect to VPN points all across the world, and see how easy it is to protect your data without slowing down your web traffic. So try it below. 30-day money-back guarantee. nordvpn.com/EmilyDBaker. Thank you again for sponsoring this week's video. Seriously, the chances of me having my hair actually heat styled in both my Nord ad spot and tonight's video are literally like a 1 in a million. So if you're in kind of a betting mood, that's never going to happen. This is like a once every 3 weeks type of a thing. It's as my hair, look, it's gotten ridiculously long. I have to go get it. When we do Galaxy hair, I have to get it cut because it's gotten very long, but it takes a lot more time to like do the things. to do the things. So I see you in the chat sharing that you've tried Nord and really like it. Sarah, thank you for that feedback. I've been really happy with them too. So let us get into our first annoyance of the night with the weekly round. This is coming to us from the Western District of Arkansas. Josh Duggar was supposed to be sentenced on April 5th. Emily, did you have a plane ticket booked? Yes. Did you know that the sentencing could get delayed? Yes. I booked everything so that I could handle the booking if this did get delayed, because sentencings, especially, it's a first setting on a case where he faces prison time. So I absolutely knew that this was a possibility. That said, the timing on April 5th just worked so well for me. It worked so well for me. And now it's been put over. So here's what we've got going on in the docket on the Duggar case. Text order only, which means there's no downloadable order here. It's just a text order resetting the sentencing as to Joshua James Duggar for May 25th, 2022, 9:30 a.m. in Fayetteville. This is the courtroom. That is the judge. The text order only granting the motion to continue the sentencing. Look, when we saw that the government didn't object, it's a first setting. We knew they were going to give more time. That is what I told you guys was going to happen. I'm like, this is probably going to get granted, but it officially got granted. So here we are. The other documents that have been filed under seal, I've seen some confusion of these online, probably stemming from people going through the docket who don't understand what these actually are, speculating about what they are. But these are sentencing recommendations from the pre-trial sentencing unit. So these are from pre-trial sentencing, the PSR unit. The pre-trial, or not pre-trial, the sentencing unit, I shouldn't say or post-trial, but the sentencing unit that deals with putting together the probation sentencing report is, they do an interview with Josh Duggar. They do more investigation. They are an independent entity that works with the courts. It's not the defense attorney. It's not the prosecutor. They filed their initial document. So when we go through this, they filed their initial document, initial disclosure copy of the pre-sentence, see, I'm saying pre-trial, the pre-sentence investigation report was filed back in February. Then the attorneys have time to file responses and objections or give more information. And then the final document and sentencing recommendation is filed with the court. This is separate from the defense's sentencing motion and the prosecution's sentencing motion. Those sentencing motions will be filed. They may be filed under seal. They may not be filed under seal, depending what's in them. What we do know is that this final pre-sentence investigation report was filed with a victim impact statement. Those are all sealed, probably because it is filed with a victim impact statement. So those documents are from a division of the court, not from the attorneys. And this happens with probation before, in the pre-sentencing stages, that there are pre-sentencing reports. And then after trial, you get pretrial reports, me now inverting the words. The pretrial reports come before the trial with, recommendations if somebody's out on bond or bail and, things like that. What should be the recommendations? They sit down and have an interview with the person after they're arrested and indicted and then either bonded out or what have you. So there's two different procedures that go on, one at the beginning and one now, but these are interviews with officials that work with the courts. So that is what all of those sealed documents are. We will still be getting documents, hopefully not under seal, from the prosecution and from the defense attorney. Those are due 14 days before this May 25th date. Guess where Emily's going to be on May 25th? Not in Arkansas. Unfortunately. I'm really bummed. I was looking forward to meeting the Arkansas law nerds. I was looking forward to being there for the sentencing and not having to rely on reporting of it. But it's not going to be streamed. It's not going to be available via video, and I am speaking at a conference that I am excited to go to, be committed to, and see honored to speak at alongside, Justine. Could I fangirl any harder? And like Gary Vaynerchuk and Shalene Johnson and others. So I'm going to be in Vegas. And can't be in Vegas and Arkansas at the same time, unfortunately, but what are you going to do? So with that, it is time to talk about what is going on another docket. Let's go talk about the Jen Shah docket real quick. A lot has been going on the Jen Shah docket as it's ramping up for trial, now reset into July. But for our purposes today, we are going to quickly talk about the fact that the court has set a hearing date for the hearing with regard to the motions to quash. As you may remember, there was a documentary limited series. It's not even limited. It's one episode. There was a reporting piece special called The Housewife and the Shah Shocker about Jen Shah that aired on Hulu and was made in connection with ABC. I've broken down the subpoenas where Jen Shah's attorneys took a scattershot approach and were like, yo, give us your shit. We would sure love to see everything, all of your interviews, your notes, your unaired footage. We would love to see all the things. And all of the attorneys were like, what we're not going to do. What we're not going to do is literally give you all of our shit. So they filed their motions to quash. I like calling them motions to squash subpoenas because that's what they're trying to do. They're trying to be like, but Your Honor, they can't do this. Stop it. None of this. So with that, the court has set a hearing on this instead of just ruling on the filing papers. So the attorneys will be back in court for a hearing on, let's make this just a little bit bigger. Where's my I have a make it big button. Wait, I made the wrong thing big. Hold on. There we go. There's my make it big button. It's ordered that the court will hear oral argument on defendant Kevin Handren's motion to quash defendant's Rule 17C subpoena to non-party Samada, I think it's GUA, Guha, an interested party, American Broadcasting Companies, Inc.'s motion to quash the subpoena issued upon it by defendant Jen Shah on Thursday, April 7th at 12 p.m. I imagine that the court is just going to say, this is not narrowly tailored. You can't do this. This is not narrowly tailored at all. What you can't do is just literally ask for fucking everything. So the court will either just deny it and be like, just stop, or the court will ask the defense to narrowly constrain the subpoena, or the court could say, you know what, you can get this type of information. So this is a discovery issue. There are multiple other motions to quash, but this docket has absolutely popped off in the last few weeks. It has just been super busy. This is the Shah docket. And yes, for those of you that are astute, the different jurisdictions do have different colored dockets. So it's very interesting. You know where you are in the docket. So you've got to get through all the defendants on the Shah docket. It is much, much longer. It is much, much longer than the Duggar docket. So we've got new sealed documents, which is interesting because we saw that Stuart Smith was supposed to be sentenced and then wasn't, and we don't quite know what happened there. And then there's been a number of different sealed documents. We also have an opposition to a motion to vacate that's been going on with regard to a different defendant, this defendant, Derek Larkin. We have a motion for sentence reduction from Derek Larkin. This is the reply memorandum by ABC. We haven't broken those motions down, but I'm going to go through them and do a summary of them next week. We also have some Brittany motions to get to. So there's been a lot of litigation going on with regard to the ABC subpoenas. So that's what we're going to do. And we've covered from the March 4th up. So with that, it is time to move on. It is time to move on and talk about what is going on in the trial of Jovan Vavik, because I am never done with this story. Not going to be done with this story until there is a verdict in this trial. I am not done with this story. This is just, I am fascinated. It needs to happen. We have things to talk about until this trial is over. If you've not been following along, this is one of the few varsity blues college admission scandal trials. This is regarding the USC, University of Southern California, men's water polo coach. Sorry, I have got to move my chair. It was making me crazy. USC men's water polo coach. The government has alleged that this coach was accepting bribes and other forms of payment to fake recruits to help them get an easier time to get into USC. So this case has been going on, and we've been doing quick bit updates every live stream because quite a lot has come out, including the fact that this coach had his kids' private school tuition paid for by the orchestrator of the whole like college admission operation varsity blues thing, where it was like, yo, I've got these rich folks. The rich people want to pay to get their kids guaranteed easier admission into school. So you water polo coach, if you just pretend these kids are recruits, we could just stick them into the pile and maybe get a more favorable look from the admissions office. So they're alleging that there is payment, including the payment of private school tuition that was going on here. But it seems like the judge tested positive for COVID. So now the trial is just on pause, which always kills the momentum for the prosecution and can make it a little bit more difficult. So the trial halted on March 23rd due to the judge testing positive for the vid, and the court is slated to return on Monday, but now the trial is going to resume after a CDC quarantine period, maybe Tuesday, maybe later. So there's nothing happening. The judge tested positive for the vid. It's so anticlimactic. But this is going to be a problem for trials coming up. I was talking to one of my nearest and dearest friends who is running for judge in Los Angeles County. So if you're in LA County, Barron for judge, she's running for seat 60. And I will share a link if any of you ask. I'll share a link down in the description. But we were talking about her starting trials in LA. She is still working as a district attorney. And she's had multiple trials come up where it's like the defendant is now in quarantine, the defendant is in isolation. So this is an ongoing problem, particularly when people are in custody in the criminal realm. But courthouses are literally harbingers of illness. Courthouses are so gross. I was working at the court when I got horribly exposed during a tuberculosis outbreak, but there have been measles and mumps outbreaks. There have been outbreaks of all manner of things. One of my friends got MRSA at the court. Courthouses are nasty. So if you have to go to court, if you are going to observe cases, literally wipe it down like it's an airplane. Courthouses are, and this was that courthouses have been nasty. So with that being said, it's going to keep happening. I know in LA County, they have like a pre-trial unit within the men's jail system so that people can be isolated before trial to try to not have this happen, but it does absolutely happen. So boo on the Varsity Blues trial being on totally paused, but also what are you going to do? It's on pause. Let's talk about Wendy Williams real quick. Let me pull up what I wanted to pull up. I'm going to pull up Instagram real fast and make sure that my sound is routing through so y'all can hear it. And I'm going to put my headphone on because we will probably talk about it just a little bit. So let me, there we go. Things are happening. I shared this out on my Instagram. If you guys don't follow me on Instagram, I'm at the Emily D. Baker. I should swoop. I should swoop. I should swoop. We're going to talk about this real quick. I have a video breaking down the Wendy Williams Wells Fargo wildness of it all. So if you haven't seen that, it is timestamped. I will be breaking it out over on the Quick Bits channel as well, because I have the documents from the court before the entire damn docket got sealed on motion of Wells Fargo. There have been no updates to that docket since February, and we have not heard much about it other than Wendy Williams being able to speak out. I am not going to go through her entire Instagram video, just a little bit, but her video does touch on things that I covered in those petitions that we had. And she talks about people that are related to those petitions that we've already covered with regard to Wells Fargo freezing her assets and seeking to place her under a guardianship. Unfortunately, everything is sealed. So other than Wendy Williams sharing about it, there is nothing else for us to legally break down. What I will say is that it was very odd to me that in New York, anyone can file for a guardianship. And based on this last video, it seems that that is still proceeding forward. So I am going to share this link to the mods so they can share. Let's see if I can share the Instagram link. And I'm going to give it to the mods so we can put it in the description too. If you guys want to go look at this Instagram video in its entirety, it is still up on Wendy's Instagram. But when we talk about this, look, I know Wendy is going through health struggles. You can go through health struggles and not be placed under a guardianship. The fact that Wells Fargo is the one moving for a guardianship is odd to me. And the fact that all of her accounts still seem to be frozen based on what she's saying is very, very odd to me and very, very frustrating. I can't imagine how powerless it would make someone feel to be like, I can't get to my money. She also talks in this video about a doctor releasing information to her bank, and that is brought up in her filing documents as well. It is very strange and very problematic if a doctor that has seen Wendy Williams is releasing that information without her permission, is the crux of this, to a banker. It doesn't make sense. Like, it doesn't make sense. So there's a lot here. I'm just very frustrated that we don't have access to it. So let me put on my headset so I can make sure that we can all hear. Hopefully you all can all hear, and we'll look a little bit at what Wendy Williams had to say on Instagram. Hopefully. We should unmute it.
My thing is that I've been
asked. Hold on. Let me see if that helps.
Asking questions about my money.
All right, I'm going to start back at the beginning because I couldn't hear.
My thing is that I've been asking questions about my money. And when I began asking questions about my money, suddenly Lori Schiller has got no response regarding my money.
We know from the filings that I have gone through on the channel that Lori Schiller is her former financial manager that worked with Wells Fargo. So she was indicating in her filings that she was trying or had fired Lori Schiller, and they weren't letting her do what she wanted with her money, which is very, very odd. So it's a very strange circumstance.
I want my money. This is not fair. And Wells Fargo has no questions and answers with regarding my money.
Which is very strange. So in her filings before they were sealed, she was arguing that she had been going to Wells Fargo branches, or one particular branch in Florida, and actually got someone to have power of attorney and was saying, "Hey, I've done the things you're asking me to. Why can't I have access to my money?" And they still did not give her access to her money. That is her side of this in her filings. It's a very strange situation.
My thing is that I've been asking questions about my money. And when I began asking questions about my money, suddenly Lori Schiller has got no response regarding my money. I want my money. This is not fair. And Wells Fargo has no questions and answers with regarding my money. This is not fair. And Lori Schiller and Wells Fargo have this guardianship petition about keeping me away from my money.
And so we know that Wells Fargo, based on their filings in court in New York, Wells Fargo has filed to get a guardianship over Wendy Williams, not meaning that they are going to be the guardians. I don't know who they're asking to have the guardians because we don't have access to any of that. It's all sealed. But they were the ones who filed the petition seeking a guardianship over Wendy Williams, which is a very, very odd circumstance, a very odd circumstance.
This is not right.
I agree, Wendy. It's not right.
And you know, this is not fair. And this guy named Bernie Young, I know for a fact that Bernie Young used my American Express card to hire an attorney to file a petition against me.
And that's something that she will have to look into with her attorneys because somebody shouldn't be using her cards to file petitions against her. It's very, very odd.
That was done with my American Express card. Bernie Young, you're no good. And this is not fair at all, you know? And then there's this person, this a former doctor.
This also is so strange to me. I just can't envision how this went down. And I hope that her attorneys are looking into this more deeply.
A former doctor, okay, had medical information about me that I never even got. It was sent over to Lori Schiller. So I haven't gotten the stuff.
A doctor sending stuff to her financial advisor without court order, without her authority, is very, very, very strange, and shouldn't be able to happen. So that's something that's going to need to be looked at as well, because that shouldn't have happened. But the medical information seems to be part of the basis of why Wells Fargo froze her accounts. But but they shouldn't have that information unless she authorized the release. From her statement, it doesn't sound like she authorized the release of that information. Again, if she released it, it's different, but based on her statement, it doesn't sound like she did.
I fired the doctor, and again, all I want to know is where
She tried
is
to
my
file
money.
Lori
This
Schiller
is not
too.
right, and certainly, this is not fair. This is not fair.
I agree. She seems deeply stressed about this. I can completely understand the stress here. And I understand like all of the self-soothing gestures speaking out about this. Because like we saw in the Britney Spears conservatorship case, with Britney, there was major concerns by her based on her later statements in court that she would be punished for her behavior. And so I worry that Wendy Williams is in a position where she is concerned that if she speaks out about this, what else are they going to try to do to me? It's very strange. It's deeply concerning. I hate that all of the documents are sealed. It doesn't make sense the way that they've been sealed. It doesn't make sense that they are completely sealed. I'm glad I got them when this first happened. And the reason I got them when this first happened is because of all of you. If it weren't for the law nerd saying, girl, look at this now, I probably wouldn't have looked at it immediately when it was happening. And it might have been too late to go and get those documents once the court sealed the records. So thank you again for those of you, and there's so many of you that reach out when stories are of interest saying, are you seeing this? Are you seeing that? And a lot of what I see is because you guys bring it to my attention, and that is so tremendously helpful. So law nerds, thank you. At least we have them. We have the documents, and we can continue to look at least looking at what's been filed and what we know, and lining it up with what Wendy is saying on Instagram. And what she has filed lines up squarely with the statements that she's making on Instagram. This has been very, very consistent. So I am tremendously concerned. I know she has an attorney, and I am optimistic that her attorneys will do right by her. I have to be optimistic in that. So I am nervous. And the stuff with the doctor is very, very, very strange. I was talking to Dr. B about it, and he's like, wait, what? But of course, we don't know if they got her to sign something. Or Lori, this will get into me just wildly speculating, and I don't want to do that. But we don't know if they got her to sign something and how Lori Schiller ended up with this medical information, but it is brought up in the original documents. And so I'm not surprised it's being brought up again. So here we are. If you have not seen that live stream, it will be here. And I will also put it up on Quick Bits and let you guys know if you haven't watched my breakdown of all those documents, because it's up on the YouTube for now. Fingers crossed they weren't sealed when I got them. And I don't think that sealing order is narrowly tailored. I have questions and issues with all of it. So from medical to medical, we are going to move on to today's verdict in the trial of a Vanderbilt RN. So let us. I have not been following this case super closely. A number of you have asked me to talk about it, and I will look into the statutes here later now that I have seen the verdict come down. But in this case, and again, this is from the Tennessean, because Vanderbilt, because Tennessee. The ex-nurse Redonda Vaught was found guilty on 2 charges today in the death of a patient. The questions that this case raises is, when is a mistake criminal negligence? And that is something that we absolutely are grappling with across cases that we are covering, because again, they argued in this case that the nurse did not intend for the patient to pass, that this was not a willful case, that this was criminal negligence because and I'm going to mess up the second medication here. I know what Versed is, but the patient was supposed to receive a dose of Versed, a sedative, instead received Verconium, I think, which left her unable to breathe. The prosecutors talk about the fact that there would have been warnings and that those would have been ignored when the medication was taken out of the medication cabinet. It's an interesting verdict, but when you look at the way negligent homicide is used, I don't know if this is what it's necessarily intended for, if it was a mistake. And it seems that quite a lot in the medical field are saying that this was a mistake. So the district attorney argued that she probably did not intend to kill, but made a knowing choice. And that knowing choice being that knowing choice being the overriding and pulling out the medication, it's going to be very interesting to see what's happening. So with that, um, I will be interested to see what happens in the Rust case, because with this type of mistake, you have someone who was in the position to know what they were doing, to check the thing they were doing. It seemed like the hospital had a system of when you get drugs out that you know what it is. So those were the factors that went into her being charged in Tennessee, a different state than New Mexico, with negligent homicide. But negligent homicide is exactly what we're talking about when it comes to Alec Baldwin shooting and killing someone. So that is what was ruled on. I'm going to look at this more in the context of, you know, how this plays into a potential decision in the Baldwin case, because I haven't seen anything in all of the articles I've read about this case. And again, this is a case I am just jumping into, but I haven't seen anything that has stood out that this was anything more than a mistake with a, but you should have known better. And is this the direction we're going to go with criminally negligent homicide when people make mistakes at work? And so the question comes in multiple different contexts. I know the chat, I saw a couple of you already mentioning the Kim Potter case. Look, when we're talking about mistakes made, then we're talking about mistakes made at work. We're talking about this case. We're talking about the Baldwin case. We're talking about the Kim Porter case. So it will be interesting to take a look at this in that context. It's always awful when somebody dies, and it's awful when, for the person who causes the death, it's not going to ever leave her whether she was convicted or not, and was convicted. So we will see what happens from here. I will be going through this a little bit more deeply, because a lot of you have asked about it, to kind of look at the facts that pointed to why this was charged. And again, Tennessee being a different state than New Mexico, but looking at the facts of why this was charged. And in 2017, so this incident occurred long before we ended up into deep COVID fatigue, which also concerns me for our healthcare workers and the amount of fatigue that they go through. So this is my train of thought with this case. So I wanted to bring it up because there was a verdict here. I know that many in the medical field do not love that this was prosecuted, and I'm sure don't love the way that this turned out. I am going to be looking at this more deeply to see what factors there are that pointed to this being charged for a criminally negligent homicide, and how that might play into other cases. So that is my thoughts on that. I know a lot of you have asked about it. I don't think that this, again, state prosecutions, and this is a state level prosecution, is a choice made by that state's prosecutorial agency. And generally that goes county by county. So the choice of a prosecutor in Middle Tennessee is not going to necessarily change the choice of a prosecutor in New Mexico or Southern California or what have you. So when people look at, like, will this have larger ramifications? I don't know. I can't see another prosecutorial agency going, well, because they prosecuted here doesn't mean they won't prosecute. Because they prosecuted there means we should. Juries are different in different places. Hospitals are different in different places. Procedures are different in different places. So I don't think this is going to have a large overarching wave of this. And I'm sure this wasn't a charging decision taken lightly by the prosecutors. So I know that this was dealt with by the nursing board. And we will see. Again, this is a case that might not have been prosecuted elsewhere, but was prosecuted in Tennessee. And with that, we're going to talk about quick bits, not quick bits, about TikTok. TikTok. We're going to talk about TikTok. So thank you for all of that. I absolutely will be looking at your input on this. So we will see. We're going to take a deeper look at criminally negligent homicide. And when we do that, I'm going to add this case to it and take a look at criminally negligent homicide here in the Kim Porter case, in the Russ shooting, and kind of take a look at those across the different spectrums of essentially a death being caused when you are at work. When you obviously don't intend, because I don't think in any of those circumstances a death was intended, when you don't intend a death, but a death was caused at work, because we need to absolutely look at it. So with that, I saw a question that I'm going to get to. Normally I get to questions at the end, but also ADHD. So I get to questions at the end, unless something catches my eye and I get to it immediately. Do things get prosecuted just to establish precedent somewhere rather than because of the severity of something? No, they shouldn't be. I don't think that's a proper use of prosecution. Prosecution and charging decisions are made by the elected district attorney that covers that particular area. And I'm talking about state prosecutions. Federal prosecutions can be different. This was a state prosecution. State prosecutions are charged by, the district attorney's office sets a policy, and that policy, that elected official's policy, is carried out by the district attorneys that work in that office. So they are choosing to prosecute it for a reason, either because it is a crime, because they believe they can prove that crime beyond a reasonable doubt, because they believe there's no other option but for to charge this crime. There's not, diversion isn't what it's going to work. Michelle Obama's bestie hasn't called up the DA and asked them not to charge it, things like that. So there is always a conversation to be had when it comes down to licensed professionals when something happens at work, whether revoking someone's license is enough and things like that. So all of those conversations would have been had. I don't think this is a charging decision that would have been taken lightly, but I want to look at how this got to the police in the first case, because not all deaths in hospital even end up with a criminal investigation. And so that is something I will be looking at, but I wanted to mention it today because the verdict came down today. Sandy, this is one of my favorite things to drink. I love Baileys and hot chocolate, and that made my tummy rumble like a little bit. Yep, certainly did. Made my tummy rumble a little bit. I was like, ooh, yum. Let's talk about TikTok getting sued real quick. This is coming to us from Twitter. I saw a Verge article on Twitter, so I'm going to pull up the Verge article and then I'll pull up the, let me pull them up together. Let me swoop and I'll pull them up together. TikTok's getting sued again. I talked on the Emily Show podcast about TikTok getting sued a number of times. Most of the stuff TikTok was getting sued for was for privacy. In this lawsuit, TikTok is getting sued by former content moderators in what is looking to be a class action against ByteDance, the parent company, and TikTok. So I'm going to go to the Verge article first because I saw it pop up on Twitter. And for those of you that follow me on Twitter, I shared it out and was like, yo, if you're interested in this, let me know. And a lot of you were like, I am very interested in that. So again, not to constantly plug, but if you want to follow me on social media, I'm at the Emily D. Baker across platforms, including the TikToks. And this is probably going to bing soon. Y'all, if you're watching, we have like 2,500 of you here. If you haven't subscribed, do the likey, subscribing things. We'll see if we bing this evening. Let's go to this article from The Verge. Oracle says ByteDance will have nope, this is the wrong article that I pulled up. Wrong Verge article. That's from an older TikTok lawsuit. Did I pull up my notes from the older TikTok lawsuit? Yes. Yes, I did. Fantastically prepared. We're professionals here. Sometimes these things happen. I hate having dead air, but sometimes these things happen. So I'm just going to go, we're just going to go directly to my Twitter and pull it up from there. Where is it? Here. Oh, it's a CNET article. See? No wonder I was looking at the wrong thing. I thought it was a Verge article. It's actually a CNET article. All the things. All right. Former TikTok moderators sue over work-related trauma. I'm traumatized by people popping into my office right now. I'm so distracted by noise. I can't tell if it's Dr. B, one of the kids, or the other pawnerd. I can't tell at all. All right. Former TikTok moderators sue over work-related trauma. The pair alleges TikTok didn't do enough to protect them from post-traumatic stress brought on by viewing disturbing videos. This has come up for both Facebook and Google, that there have been lawsuits over those who moderate content on the platforms not being protected in what they are doing and the things that they are exposed to. So let us see. 2 former TikTok moderators are suing this. I imagine, by the way, because they're positioning this as a class action, that we will get more people joining this. 2 former, so y'all, I think I need to say right now, don't traumatize my moderators. Y'all, don't traumatize the moderators. All right, let's keep going. In the federal lawsuit filed Thursday and reported earlier by NPR, Ashley Velez, and Reese Young, who both did moderation work for TikTok through third-party companies, and that is going to be part of this as well, say they spent 12-hour workdays reviewing disgusting and offensive content that left them emotionally scarred. I doubt this zero. If you guys have been in the chat when the chat has gotten polarizing, and sometimes when we talk about polarizing things, like maybe later, but y'all are law nerds, you know how we do. It can be hard. The work I did was hard. It can be hard to see people who are popping off against something that you believe in, and you're like, ugh. Or people who are saying hateful things, like this content that we sometimes come across on social media, and you're like, I hate this. Imagine being the person that has to block it from getting onto the internet. Like, that's a whole nother level of it. And it can't all be done by algorithms. And this is the push-pull when people talk about, we need more human moderation, and sometimes the algorithms don't get it right. I understand that, but also there's a human cost to it. And I think this will open up the conversation about human cost. It's easy for creators, and I have done this too, to be like, the algorithm just doesn't get me. There was a particular video where I talked about the name we had given to the wide breadth of lawsuits coming in during the Tati Westbrook stuff. And we called it SUENAMI, like sue. Nami. And YouTube decided that video could not be monetized and needed to be restricted because of a graphic depiction of a natural disaster. And I was like, y'all, literally, we're talking about beauty influencer lawsuits. We're not talking anything about natural events, but that can happen. So it's just a back and forth between the human cost and getting it right and getting it wrong when it's with the algorithms. I am always a little bit more like, it can happen if things are wrong, because also I get the human cost. Like, I get it. Because when you're filing cases as a district attorney, you see all of the shit. So I get it. So we're going to talk a little bit about what they say they saw. I'm not going to get into it graphically today. If we need to cover this lawsuit more, I will give all the appropriate warnings. But they are saying they were reviewing disgusting and offensive content. Don't doubt that at all. Some of the worst videos showed animal cruelty. Don't doubt that. Abuse, disturbing, PORN, and even killings, the lawsuit says. Like, literally, what the fucking snuff film bullshit are people trying to put onto TikTok? I've told the story about my friend at the DA's office who ended up with the blue smoothie all over his very white work shirt when he had to go to court, and had made a joke about Smurfs, and just covered. That particularly DA was also the animal cruelty DA for our courthouse. And the shit that came across his desk was stuff that I was very thankful I did not have to see. Though sometimes when we were reviewing cases together, I did, but I was very glad that that was not my role. When people are like, Emily, fraud cases, really? I'm like, give me bank records all day long. Give me back. Because if my options are child abuse, animal cruelty, and dead bodies, just give me bank records. Let me see the doo-doos in custody for money laundering through PayPal, and his girlfriend is paying for Match.com while he's on the inside. Give me that all day long. All of it. All. I want all. Millions of videos are uploaded daily to the Chinese-owned app, which has more than 1 billion, with a B, active monthly users. About 10,000 moderators police its content to keep it free of the kind of imagery the lawsuit describes. The suit alleges that TikTok and its owner ByteDance violated California labor law because they didn't provide adequate mental health treatment to help moderators deal with anxiety, depression, and post-traumatic stress that can be caused by such imagery. Other companies have had to deal with this. I said Facebook and Google have had to deal with this already. Both plaintiffs were contractors who worked for separate firms. This is going to be important in the lawsuit. But they allege in the suit that TikTok and ByteDance controlled their day-to-day work by directly tying their pay to how well they moderated content and by pushing them to hit tough quotas. And I think from reading this, and we're going to look at the lawsuit real quick. We're not going to dive into it too deep today. When third-party firms are hired by TikTok, especially when we're talking about California, it seems that TikTok is trying to avoid having all of these individuals as employees. So instead, they are contracting them through third parties, trying to get around making them employees of ByteDance or TikTok. However, California might determine that these are properly employees and that suing TikTok is proper. They might also have to sue, though, the companies that they were hired by. And I don't see that yet in these lawsuits. They might have to sue ByteDance, TikTok, and the other companies. But if ByteDance/TikTok has an indemnity agreement with the other companies, it might be, if we get sued by your people, you are on the hook for it. So there might be an indemnity clause there. There's like some deeply legal wrangling that might happen with the fact that these were contracted through third-party companies. But of course, they're making the argument that ByteDance controlled their day-to-day because that's how you sue ByteDance and not just the company you contracted with. The suit says they also had to sign NDAs, preventing them from discussing what they saw with anyone. Generally, NDAs do not extend to things like therapists and lawyers and court proceedings, and shouldn't extend to things like therapists, because that's just Officials for TikTok didn't immediately respond to CNET's request for comment. They told NPR that the company strives to promote a caring work environment for our employees and contractors. Okay. In 2020, Facebook reached a $52 million settlement with a group of its moderators. That group filed a suit in 2018 saying that the moderators had suffered similar post-traumatic stress as a result of the content they had to view. I wonder why they didn't bring the Google one up. I'll have to look and see if it's still ongoing. It might still be ongoing. The lawsuit against TikTok seeks damages and legal fees, as well as the establishment of a fund to pay for medical monitoring program to manage ongoing screening, diagnosis, and treatment of the two plaintiffs, as well as others who may join the lawsuit later. And I imagine there will be lots of others. They are setting this up as a proposed class action. This is filed in the Northern District of California by the two plaintiffs. Again, introducing what TikTok is, what the app has. I'm not going to go into this in more detail because I'm sure they will more graphically describe some of the videos, and we're not going to do that tonight. It's Friday, but we're going to look at exactly what their claims are, because that is what I want to see. So jurisdiction and venue, where are they alleging that ByteDance works. Oh, here's the parties. Okay. So Reese Young is a resident of Nashville, Tennessee. Ashley Velez is a resident of Las Vegas, Nevada. ByteDance is a Delaware corporation with its principal place of business in California. So they just said, you know what, we're going directly to where they are. Also, the employment laws in California are very employee friendly. And it's a proper venue because it's where the principal place of business is for ByteDance. Defendant TikTok is a California corporation with its place of business in Culver City. I didn't know that. Defendant TikTok also maintains an office in Palo Alto, California, a little rundown building in Culver City. I didn't know they were on Bristol in Culver City. Fascinating. Sorry, I digress. In fiscal year 2020, ByteDance made approximately $34.3 billion with a B in advertising revenue. In 2019, that number was $17 billion. So TikTok did well during 2020, didn't they? Let's see. Let's get to the causes of action. We're going to skip the factual allegations for now. Defendants recognize the dangers of exposing users to images and videos of graphic violence. In December 2020, TikTok updated its community guidelines, which is interesting because they're going to be able to argue, look, you didn't want your users to view this shit because you knew it was a problem. It was a problem for us too, TikTok. Repeated exposure to graphic imagery can cause devastating psychological trauma, including PTSD, anxiety, and depression. They're not going to have a hard time proving that. They're just going to have to prove the types of things that they saw. This gets into the employment stuff, which we will come back to and do a deeper dive into if you guys are interested in a deeper dive. Defendants failed to implement meaningful protections for their content moderators. Defendants failed to implement workplace safety measures, and you have to have workplace safety measures. OSHA doesn't just count for physical safety that meet industry standards that other companies and nonprofits have implemented, Google, Facebook, and have failed as well to implement the standards suggested. I just hit my mic, which then moved my camera. Sorry. Suggested by the Technology Coalition, despite its being a member. During the hiring and training process, defendants do not cause content moderators to be informed of the nature of the work. That is, if true, that is going to be a very big problem. To be informed about the nature of the work or the effect of reviewing graphic content, because Google did do that. Google did talk about with their moderators, like if you are on this moderation team, you are going to be dealing with this type of content. So not letting people know the type of graphic content they are going to be exposed to is definitely going. Can you imagine just being like, oh shit, that's happening. That's happening. That's happening. Training videos were significantly tamer than what plaintiffs were exposed to while on the job, leaving them unprepared for the mental stress and harm that they would be subject to. Let's go to the causes of action. Here we go. Class action allegations. They're going to allege that there are enough people in the class that worked as moderators that they can properly be joined. First cause of action, negligence. Abnormally dangerous activity. The company is strictly liable, which means like it happened, you're liable. It happened, you're liable. A company is strictly liable to individuals that are injured while the company engages in abnormally dangerous activity. Activity is abnormally dangerous if it A, necessarily involves a risk of serious harm to the person, land, or chattels. We love chattels. Property of others, which cannot be eliminated by the exercise of the utmost care. Yeah, it's the nature of the job. You can't eliminate the dangerous. You can't eliminate the dangerous condition because it's the job is literally the dangerous condition. And is not a matter of common usage. And then requiring content moderators to review graphic and objectionable content is an abnormally dangerous activity. Content moderators are at risk for serious and debilitating psychological trauma, including severe anxiety, depression, PTSD, and there's no way to eliminate that risk. Content moderation is also not a matter of common usage. Only a handful of technology companies, nonprofits, and government agencies and NGOs review content. Strict liability for I wonder what YouTube does, because Google's suit was not about YouTube, it was about search, which is interesting. Sorry, my brain just went, I've got questions. I've got more questions. Strict liability for a defendant that engages in abnormally dangerous activity represents a social policy determination that the defendant, while engaged in an enterprise tolerated by law, must pay for the damage caused by the enterprise. Then they talk about the fact that, TikTok earned approximately 1.9 billion in revenue from TikTok through ByteDance in 2020, and that it's because of the got a natural engagement pattern. Okay, I don't know if this is going to be instructive, but I'm glad the lawsuit cited TechCrunch.com. Fantastic. They're going on to say, in addition to deriving a vast amount of wealth from the removal of graphic and objectionable content by plaintiffs, right? Because it keeps the advertisers happy. Defendants also derive engagement from objectionable content that continues to remain on the platform in the period between the AI review and the human review by content moderators, including plaintiffs. Therefore, more revenue is churned for defendants from keeping such content on their platform. Yet amidst this high revenue churning process, plaintiffs continue to remain disadvantaged as a result of defendants' tortious conduct and flagrant disregard for ethical and industrial standards of care toward their content moderators. They're asking for medical monitoring that provides specialized screening, assessment, and treatment, not generally given to the public at large. And then they talk about what they want that to be. Let's see. Second cause of action, negligent exercise of retained control. Plaintiffs reallege and incorporate all the shit above. The hirer of an independent contractor is liable to an employee of the contractor insofar as the hirer, in this case, ByteDance, negligent exercise of retained control affirmatively contributed to the employee's injuries. So did ByteDance contribute to the injuries? Because ByteDance is who they are moderating for. If an entity hires an independent contractor to complete work, but retains control over any part of the work, the hiring entity has a duty to the independent contractor's employees or subcontractors to exercise control with reasonable care. They say that defendants retained control over certain aspects of the work performed by plaintiffs, including requiring content moderators to use defendants' proprietary TCS software that presented unmitigated traumatic content to content moderators without adequate safeguards, requiring that content moderators sign NDAs and undergo defendants' developed confidential trainings that prohibit content moderators from discussing their work outside their review teams. You have to be able to discuss it with medical and legal professionals. Constantly monitoring the work being performed by content moderators, requiring that content moderators be sent daily adherence letters and weekly calibration tests. I have so many questions. Requiring the content moderators be Hi, Fred. No, we can't. No. What? No. Hi. Requiring the content moderators be interviewed and undergo training using training materials and procedures created by defendants. Well, it seems like they had the opportunity to tell them what their jobs would include. Setting unrealistic and onerous quotas. Setting quotas is definitely an indicia of control. Setting quotas is definitely control. So all of these things are like, hey, all of these things show that they were in control of the work. Based on its exercise of retained control, defendants have had at all relevant times a duty to exercise reasonable care with regard to the safety of plaintiffs, and that they're saying they negligently exercise that control. For example, defendants failed to provide adequate technological safeguards to protect content moderators from the risk associated with exposure to traumatic content via their TCS software. The NDAs and confidentiality requirements diminished content moderators' social support networks and reliance by prohibiting content moderators from speaking about the content they reviewed with other related workplace conditions with anyone outside of their review teams. And defendants failed to provide content moderators with an interview process and training to meet industry standards for mental health of prospective content moderators. Defendants were aware of the psychological trauma that could be caused by viewing graphic imagery. We're not going to get through the description of the graphic imagery. Bad imagery, bad, awful bad. And then they talk about what those monitoring procedures would be like that they're asking for. There's a third cause of action for other types of negligence. Negligent provision of unsafe equipment. Well, how are we getting to unsafe equipment? Is it the program? Defendants provide to their independent contractors the review platform that plaintiffs and the class were required to use to complete their work. So that, I guess, is the unsafe equipment, the review platform not having safeguards. Defendants were aware or should have been aware that their review platforms could be made safer if proper precautions were followed. I'll be interested in looking at what the industry standards are for this. It is going to be very interesting to see what those industry standards are, and if there are what the industry standards they allege are based on the association that they cited. Fred is just like, no, you are going to pet me, and that is what's going to happen. And then they talk about the medical monitoring, as they talked about before. Fourth cause of action, California unfair competition law. I wouldn't have anticipated that. I'm very, very curious. All right, Fred, don't mess with my microphone, buddy. Stop it. You're going to shake my camera. That's what we're doing. Fred is laying directly under my monitor, trying to chew on my cable for my microphone. So if there is noise, I apologize. It's Fred. It's a braided cable. It's his favorite. Now he's drooling on my keyboard. Great, Fred. You're having a night. I'm putting you on Instagram after this. I am trying to live stream. All right. After we're done, I will share what Fred is doing on the Instagram. He is just having a moment. Fred, please don't hit the mic, buddy. He turned on my mini little Apple HomePod the other day, and I was like, it scared the crap out of me. All of a sudden it was very loud music. All right. California unfair competition law. How are we getting to this? Let's see. Oh, solely in the alternative. That's how we're getting here. In the alternative being the operative word. Solely in the alternative, and to the extent that this court concludes that defendants are not strictly liable for the harm engaged. Defendants' negligent exercise of retained control of the content moderation work violates California common law. So it's like, if that stuff doesn't work, this is our last option for a cause of action, because you got to bring them all at once. So they are saying, let's see, plaintiffs seek an injunction creating a defendant-funded medical monitoring program. But how are we getting to unfair competition? That the unsafe work environment means that they have more money. They didn't really flush this cause of action out very well at all, because they're just talking about what is above. So they didn't flush out the unfair competition very well at all. Maybe they didn't have to by pleading standards. I'll be curious to see what they have to say in the coming up, if this continues to go and doesn't just settle. Fred, you are just choosing violence tonight. You're going to knock the cups over and just, all right, buddy. Plaintiffs reallege and incorporate all of the above. Section 6400 of California Labor Code requires employers to furnish employment and a place of employment that is safe and healthful for employees therein. Requires every employer to furnish and use safety devices and safeguards, or to adopt and use practices, means, method, operations, and processes which are reasonably adequate to render such an employment or place of employment safe and healthful. You can't just, even though a place of employment can be dangerous, there are absolutely dangerous jobs. You have to render it as safe as possible. Fred. So that's the unsafe work environment. And then they are naming defendant as a special employer, which is going to be a statutory provision that they need to meet for this cause of action. Stop swinging the mic. All right. No employer can require or permit any employee to go or be in any employment or place of employment which is not safe and healthful. Me thinking of my old courthouse that was condemned, and then the state didn't have the money to fix it, so magically it was uncondemned, and we were all sick all of the time, and they were like, it's perfectly safe. And we're like, I don't think so. Seems like it's maybe not. I'm glad they tore it down. All right. This goes on again to them not providing any safeguards for the content moderation, and then the prayer for relief. Certify this as a class action. Find that plaintiffs are proper representatives of the class. Order defendants to pay and notify class members. Order defendants to create a medical monitoring fund for the benefit of plaintiffs and the class, which means all other moderators who fit into this class. Order defendants to pay compensatory damages to plaintiffs in the class. Award injunctive relief as necessary, meaning stop doing the things, or create a fund and things that you have to do. And then award plaintiffs and class members their reasonable litigation expenses. Fred, please get your claws off of my monitor. Thanks, buddy. All right, good boy. Come on. Fred's just like, we're doing this together. We're doing this together tonight. So that, if you guys are interested in a deeper dive into this lawsuit and some of the laws in California that pertain to this, then we will talk about this. So Patrick Games is like, I'm guessing it was the Long Beach courthouse. Ding, 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 ding. Ding, ding, ding. I now have cat hair. Thanks, Fred. We've Fred shedded. All right. We're an hour and 21 minutes in. Emily, it's going to be quick. Also, Emily, let's talk about this for longer. I don't know how deep of a dive we're going to get into other stuff. We're going to have to, because those are the things that we wanted to talk about. Those are the main events. Let's get to the main events. First, we are going to talk about Megan Thee Stallion getting sued. I've been asked a lot to get into this case with her label. We have not gotten all the way into it yet, but it is on my list of cases that we must get into, because I started reading the complaint today and I was fascinated. If you are not familiar with rapper Megan Thee Stallion, you should be, but she is at war in the legal sense with 1501 Certified Entertainment, her label. There is a previous lawsuit here that we are not deep diving into today. So there is history of this back and forth. There is a prior lawsuit between Megan and her label. They tried to resolve it. I have questions about what happened. A settlement was reached, but then it wasn't reached, but then depositions were supposed to happen, but then the suit got dismissed by Megan, who had sued them, and a new suit was brought. In the context of the new suit, it seems that Megan is trying to get away from this label as quickly as she can, which I understand, because this is a 360 deal. So they get a cut of literally everything that she does, which I can see how it happens with artists that are coming up and then years later, they're like, how am I still dealing with these people? It is very common in the music industry, but it is something that artists do not like. But the labels, and I talked about this when I talked about the Kanye suits with his label, and the leaked documents and what have you. You can see the label's perspective of, if I am investing this money to help you get to the level of stardom that you're at, then I need to make sure I'm recouping the money that I'm investing. But I can also see the artist saying, yes, but at some point, enough is enough. So with this, they are arguing over the release of something for the THEE hotties. Megan Thee Stallion is suing that something for the hotties is an album. Her label is now suing her, saying, no, it's not. You owe us more work. So we're going to take a look at, we're going to decide what is and is not an album through the course of this lawsuit, and whether or not this 45-minute Do I get to call it an album? Alleged album? The 45-minute alleged album? Something for the hotties? Whether it is an album that helps her meet her album requirement for her label, or whether it is not an album and therefore she owes her label additional albums. It is always really awkward to me when we see these contracts, and we haven't talked about Kesha in a really long time, but when we see these agreements where you've got artists that do not want to work with their label anymore and they cannot get out of their contracts and they are forced to work, like was happening in the Kanye dispute, because Kanye was saying, I'm done. And they're like, actually, you still owe us this work and we can enforce that provision. This provision is enforceable. So you end up in these strange contracts where you can literally force someone to work that doesn't want to work. Kind of like the Britney Spears conservatorship. You could just force people to work. It feels wrong then, it feels wrong now. But this is common within the music industry. I thought I had this lawsuit pulled up and now I'm like, where is it? So let me just pull up. I'm pulling up the countersuit because now we've got 1501 suing Megan Thee Stallion. So oh my God, my kids are so loud. I get again, when I talk about the ADHD things, noise distraction, it's like, it was awful when I was test taking in school because I would be like, every single noise. I need to get little noise canceling. I keep talking about that on stream. It's going to happen. One of these days, I'm going to do it. All right. So let us take a quick look at the counterclaim. Let's see. These better be the counterclaims. I need to make sure I pulled up the right one. Yes. Are these the counterclaims? Because there's an answer and counterclaims. These better be the counterclaims. Counterclaims. Please be the counterclaims. All right. Megan Pete, professionally known as Megan Thee Stallion versus 1501 Certified Entertainment LLC. Megan Thee Stallion, do we call her The Stallion or do we call her Megan? I don't know. Miss the Stallion, Mrs. the Stallion, Miss the Stallion. All of the above. 1501 is the record company that discovered MTS. Oh, we're going with MTS. Okay. MTS, Miss the Stallion. MTS and signed her several years ago when no other labels were interested in doing so. I mean, they're just putting the shade right at the beginning. Oh, my Mac is notifying you. I'm sorry. Apologies, chat. Apologies. I thought I turned off all my notifications. I thought I did. Sorry. This is MTS's second lawsuit against 1501. In her first lawsuit, MTS, and again, this is the label's allegations and shade because this is their countersuit. So they are putting it their way. So we are putting it their way. So let's get into their allegations and shade. We'll go over her complaint against them if we deep dive. We're introducing new topics this evening. We're just getting into the beginning of them. This is her second lawsuit against 1501. We're going to have to look at the claims in that one. MTS, they say, made outrageous claims that she never was able to prove. Ultimately, MTS and 1501 negotiated and signed a settlement agreement that amended the original recording contract. That settlement agreement was signed by the parties, who were each represented by multiple attorneys. As part of the settlement agreement, attorneys representing each of the parties signed a joint notice of non-suit with prejudice, meaning it gets yeeted and you cannot sue again. They're saying that MTS's lawyers never filed the settlement agreement or joint notice with the court, which means it's not enforced yet. And MTS denied the existence and enforceability of that settlement agreement. There's more here, folks. We're just not getting to it tonight. 1501 filed a motion to enforce the settlement agreement and dismiss the first lawsuit. A hearing on the motion was scheduled for February 25th, 2022. This is all very recent in time, a lot of litigation. A week before the hearing, MTS voluntarily dismissed the suit. On Friday, February 18th, they filed this suit against 1501. After denying the validity of the signed settlement agreement in the first lawsuit, MTS has admitted in her second lawsuit. Admitted it in her second lawsuit. All right, we'll get to the original petition on a deep dive. The sole issue in the second lawsuit is whether the recording Something for the Hotties, which MTS released on October 29th, 2021, is an album that satisfies her commitment under her contract with 1501 Studios. It is not such an album. They say Something for the Hotties is made up of 21 recordings and includes spoken interlude recordings on which MTS does not appear, as well as several previously released recordings. It was not original material and included freestyle available on YouTube and archival material from as far back as 2019. The result is that the total duration of new recordings featuring MTS, is only 29 minutes long. Me messing with my mic. Apologies. The recording was described in the music press as a compilation record of archived materials and some new recordings. Well, they called it a record. MTS herself describes the release on social media as freestyles y'all have been asking for, plus a few unreleased songs from my archives to hold y'all over. MTS knows that each quote unquote album must include at least 12 new master recordings of her studio performances of previously unreleased musical compositions. So if that's what the contract says, I'm not saying that it does. This is what they're representing. If that's what the contract says, that an album is defined in the contract, then this is going to be tough. So if an album is defined in the contract as 12 new master recordings of previously unreleased musical compositions, this is going to be an uphill battle if the contract defines the term that specifically, because then the lawyers and defining things is such a thing, but then it's going to be what counts as previously unreleased. Studio performance kind of speaks for itself. Master recordings is a term of art within the industry that speaks for itself. So what they said is the new recordings are only 29 minutes long, but you could have 12 songs in 29 minutes. So what they have not said here, which is interesting, what they have not said here is that the new recordings are only 20 minutes long, but it does not say how many there are. And in what they're describing, it says 12 new master recordings. It does not specify a length of recording. So this is probably where the argument is. This is probably where the argument is. 29 minutes of material, it doesn't say length. It says number of songs. 12 new master recordings. What's 29 divided by 12? I don't know. Hey Siri, what's 29 divided by 12?
29 divided by 12 is approximately 2.4166.
That's the average length of a song, isn't it? About a little over 2 minutes a song? That could be 29 minutes, could easily be 12 songs. Thank you, Siri. So if the total duration of new recordings on Something for the Hotties is 29 minutes long, if there are 12 of them, then it could count as an album. Notice that 12 new master recordings does not define length. She also knows that 1501 gets to approve the musical compositions to be included in each album. But what if they unreasonably withhold approval? And MTS knows that none of that happened here. MTS also knows that those provisions are common and that they appear in most recording contracts for good reasons. And MTS's lawyers know that these requirements have been upheld in other lawsuits in the past. Your Honor, her lawyers know these things. Well, obviously, there is some issue here. Otherwise, we wouldn't be here. MTS never sought 1501's approval for Something for the Hotties. Oh, that's why they're so pissed off. Indeed, 1501 only learned of their release hours before it came out. Oh, that's going to make people mad. Well, if they had to get approval, I'll be interested to see how the answer to this happens, because the approval is the thing. Because Approval is a thing. Ugh. By letter dated January 5th, 2022, 1501 advised MTS's lawyers that the most recent release is not an album under her contracts. Oh, by the way, we're so glad that you're releasing something new, but you're not done yet. That doesn't count. MTS's lawyers did not respond until January 24th, 2022. I mean, okay. 1501 replied just 3 days later, "Look, Your Honor, we're great." MTS filed her second lawsuit without notice or discussion on February 18th. There was obviously some discussion because there was a previous lawsuit and it was supposed to go to a hearing and then it got dismissed. So there was discussion there. All right. This is their answer. General denial, additional or affirmative defenses. These need to be preserved in every answer to a lawsuit. Counterclaims is what I really wanted to get to. Thank you also. Where is this Texas? Thank you, Harris County, Texas, for allowing general denials and not line by line denials, which are so fucking painful. We appreciate a good general denial. Yeah, we didn't do that shit the way you're saying it. On March 2nd, 2020, MTS filed her first baseless lawsuit with the shade. MTS filed that initial lawsuit to try to force her record company to renegotiate aspects of her very first recording contract that she no longer liked after she signed with new management at Rock Nation. Even though MTS is, that's the problem with signing contracts. And when I was looking at this, there were a number of interviews with Megan Thee Stallion where she's like, this is a 360 deal, which means literally a piece of everything. I signed it when I was like 20 and I regret this contract now. And that's what we're seeing in the Haley Page case too. Just because in hindsight you hate your contract doesn't necessarily mean you can get out of your contract, which is probably why the first lawsuit was dismissed, to be like, there's not much we can do here. So let's at least call this one an album and get the fuck out of this contract after we fulfill our album requirements as quickly as possible. I can understand that that linearly makes sense to me of why that would go down that way. Even though they say MTS's claims are unfounded, again, lawsuits are allegations and shade. 1501 sought to address her concerns, and the initial case was settled in a written agreement signed by the parties on March 1st. Hopefully, we'll go through that another day because it's probably attached to the complaint. MTS has accepted the benefits under her settlement agreement, but she has refused to comply with the provisions she does not like, including one directing the parties to file the joint of non-suit with prejudice, meaning you can't bring it again. Instead, MTS continued to pursue the case she had already settled for almost 1 year, or 1 year ago. Awkward. Faced with the impending hearing on 1501's motion to enforce the settlement, which MTS knew she would lose, MTS summarily and without notice to 1501 filed a non-suit with prejudice, meaning she dismissed it. Like, I'm not going to pursue this. Non-suit without prejudice. I'm not going to pursue this. On February 16th, 2022, 2 days later, she filed this lawsuit. The claim for declaratory judgment in this lawsuit is wholly without merit. So the declaratory judgment is going to be, Your Honor, what makes an album an album? Is this an album? Is it not an album? Does it qualify as an album under the contract wherein an album is defined by 12 new studio masters? Under the contracts executed between the parties, something for the hotties plainly does not meet the requirements for an album. Well, in addition, MTS has repeatedly breached her contracts, and 1501 seeks to recover money damages based on those breaches. Jurisdiction, Texas. Why? Well, we don't know why Megan filed it in Texas. We'll look at that on another day. Discovery on their discovery plan, factual background. We're not going to go through what? We're not going to go through this entire factual background. We're going to go to the counterclaims. They're mad about Rock Nation. Rock Nation is notorious in the music industry for trying to persuade its management clients to leave their record labels and sign with Rock Nation's affiliated label. The acrimony between the parties began with Rock Nation's involvement. On the advice of Rock Nation and without providing 1501 with the contractually required notice under the artist's agreement and complying with the artist's agreement's arbitration provision.
they could try to force this to arbitration if there is an arbitration provision. MTS filed the lawsuit on March 2nd, 2020. Let's see. We talked about the reaching the settlement up above. Dorothy Gale, I did not compare this contract to a conservatorship in the direct meaning of the word. What I said was music contracts that force people to work are untenable, even though they can be legal. And I do not like situations where people are forced to work, like the Britney Spears conservatorship, wherein she was also forced to work under circumstances she did not want to work under. It's clear that Megan Thee Stallion does not want to work with this label any longer, but under the contract, she can be forced to put out 2 more albums and work with them. It is the forced work that is the comparison. So despite having renegotiated certain aspects of the artist agreement and having fully released all of her claims, well, if it didn't get filed in court, was it fully released? MTS filed a supplemental petition in the initial lawsuit attempting to assert additional claims and adding 300 Entertainment and Mr. Prince as defendants. MTS's supplemental petition failed to advise the court that the artist agreement had been amended through the settlement agreement. They say that the actions violated the settlement agreement. They're not seeking to, well, maybe they are seeking to enforce it. Keep reading, Emily. Maybe they are. Keep reading. Keep reading. Keep reading. We know the timing of this suit getting filed. Further, by refusing to comply with the provisions of the settlement agreement, directing the parties to file joint notice of non-suit with prejudice in the initial lawsuit and instead continuing to pursue this case that she has already settled, MTS has already damaged 1501 by causing it to incur unnecessary attorney's fees. Causes of action, declaratory judgment. 1501 seeks a declaratory judgment. That is a court ruling. The court ruling saying this is this. Declaratory judgment, that's something for the hotties, is not an album under the contracts between the parties, that it does not meet the minimum, sorry, my bing-bonging at me. It does not meet the minimum recording commitment or product commitment for the second option period under the contracts between the parties, that it is a breach of contract. So they are suing her for breach of contract under the artist agreement and suing her for breach of contract of the settlement agreement. Ugh. This isn't going to be fast. The settlement agreement is valid and binding between the parties. It's been breached by bringing this lawsuit. Attorney's fees. You're breaching shit, so you should have to pay the attorney's fees, not us. Seeking monetary relief of $1 million and further seeks recoveries of attorney's fees, demands trial by jury, and prayer for relief. A judgment that MTS take nothing by reason of this lawsuit. A declaratory judgment that something for the hotties is not in fact an album. A judgment for 1501 against MTS for all actual damages, for attorney's fees, for costs of court, for interest, and such other relief. And that is Megan Thee Stallion clearly not being happy working with her label and wanting an album to count as an album against her recording contract, and them saying that's not what's going to happen. Oh, these recording industry contracts, man, they are so odd. So we will go over the complaint as well. Hopefully the contract's attached. I doubt it, but maybe the settlement agreement's attached and we can at least go through that. But these contracts are very difficult for artists to get out of. And we've seen that in so many other cases that we've talked about. When I broke down the Kanye West recording contracts, gosh, almost 2 years ago now, we talked about some of the other kind of famous contract disputes with Taylor Swift, a little bit with Kesha, with Prince, and others. So these contract disputes are, the music industry is going to have a reckoning with how they do their contracts, or this is going to keep happening. But I think there's at least awareness now when people sign contracts, what they look like. I don't think it's unknown that music industry
contracts can be difficult. Do we call them predatory? I don't know. I'm going to leave plenty of time for questions. Also it's time to go to a new topic. We need to talk about Johnny Depp and Amber Heard. So here we are at an hour and 45 minutes into our stream, switching over to Johnny Depp and Amber Heard and then getting to questions. Johnny Depp and Amber Heard are gearing up to go to trial in cross-defamation lawsuits. I'm going to be doing a full timeline breakdown, as I said at the beginning of the stream, which if you were not here for, hi. We're going to just do a quick chat reminder that we're going to be talking about polarizing figures, but the chat rules remain the same no matter how much you hate one or both or either of these parties. We still maintain our civility. We are talking about the context of what happened in court this most recent time, not the UK lawsuit, not the testimony in that lawsuit, not things that have been proven untrue, none of those things, just what happened in court that is leading up to this case going to trial in just a few weeks on April 11th. So please remember the civility rules. They are in place even for people that we don't like, and we maintain them no matter what. And that is what the mods do. So thank you to the mods. We do not Thunderdome the chat. We do not name call. We do not diagnose with mental illnesses. We do not. Yeah. So I know that this is a very polarizing case, but we are just today talking about what just happened in court. I will do a full deep dive breakdown. Don't you worry, it's coming. I'm going to do it a little bit closer to trial. I know there are already opinions that have been formed because so much of the information that will be coming into this trial has already come out in the public forum by way of the UK trial with Johnny Depp against the Sun, by way of other suits with regards to whether or not Amber Heard made a donation that she said she made, with regard to there was something else that just absolutely escaped my mind. I'm sure it will come flying back in at an inopportune time. There is so much context surrounding this that is allowed a deep dive. We've got deposition footage that is available on the internet. There is a lot of a deep dive available. But what happened in court is that this came up for hearing with regard to a motion for summary judgment. There have already been numerous motions to dismiss. If you are not following this case, these are cross-claim defamation cases. Johnny Depp is suing Amber Heard for defamation in an op-ed piece that she wrote in 2018. Amber Heard is cross-suing Johnny Depp for statements his attorneys made in the context of this suit moving forward. There have been multiple motions to dismiss. It has been determined that these claims, as they're at right now, can move forward to trial. We are kind of at the end of what we are going to see with regard to this going to trial. There has been a very recent motion for sanctions that was denied, and we are going to talk about that. But first, we're going to talk about the motions for summary judgment. A motion for summary judgment, in the course of civil litigation, you're going to get a complaint that says, you suck, you did this, I am entitled to recovery in the form of money or injunctions or both or other things. This is my complaint. And then you will have an answer to that, or a motion to dismiss, or in some cases, you'll have like a motion to strike, like California has anti-SLAPP. So then you get one of those things happens, and then the case goes to discovery, where the sides have to exchange information, depositions, all of the discovery process happens. Then after the discovery happens, you get motions for summary judgment. Motions for summary judgment can be extensive. I used to get motions for summary judgment sometimes in boxes, like banker boxes of files on my desk. Motions for summary judgment can include tremendous volumes of evidence showing the court, look, This is the evidence. We've done the discovery. This is what's going to happen if this shit goes to trial. And if this shit goes to trial, they can't win. And because they can't win, yeet. And motion for summary judgment can be granted in whole or granted in part. Like, oh, you're right as to these causes of actions, yeet. But you're wrong as to these causes of actions. So summary judgment motions can narrow down a case before it goes to a jury. But if the summary motion is not granted, then it can go to trial. So that's where we're at. Johnny Depp's motion for summary judgment was denied, and this moves forward. The motion in this case, the motion for summary judgment, was seeking to prevent Amber Heard from asserting an anti-SLAPP defense. We've talked a lot about SLAPP motions in context with defamation on the channel. Virginia's anti-SLAPP is a little different than California's anti-SLAPP, which we talk about a lot. SLAPP means strategic litigation against public participation. The way that Virginia defines that involves matters of public interest, not just matters that are newsworthy. Part of why I think this was filed in Virginia was because of this languaging. Clearly, things going on between Johnny Depp and Amber Heard in California are newsworthy. But newsworthiness is not the test for a matter of public interest. So Johnny Depp's side is essentially arguing, hey, Amber Heard's op-ed, there are parts of it that might be of public interest, Me Too, what have you. But there are parts of it about Johnny Depp that are a private marital matter. Those are not matters of public interest. Therefore, she cannot use or assert the privilege, the protection under the anti-SLAPP statute in Virginia. She can't argue it. She can't make a motion for it after trial. She's not entitled to it. And the court was like, no. And I was hoping, optimistically, that the court would give us a well flushed out order. And the court gave us this. The matter came to be heard upon plaintiff's motion for summary judgment, plaintiff Depp, as to defendant's anti-SLAPP immunity, the motion, and upon consideration of the briefs and argument of counsel, it is hereby ordered that the motion is denied. Really? That's it? You're not going to give us a reasoning or anything? Like, how did we get here? How did we determine that this is a matter of public interest and not a private affair? How did we get here? What are we relying on? Nope. This is what we got. It is denied, which means that as this goes to trial, Amber Heard may be able to seek anti-SLAPP immunity. However, anti-SLAPP does not protect defamatory statements. So if the statements that Heard made, which are defamation by implication, because she never said Johnny Depp's name, don't worry, we're going to get into defamation by implication when we do a deep dive. But when she implied that Depp was a wife beater and abuser and what have you, when she made those implications in this op-ed piece, if those statements are not true, if a jury finds those statements to not be true, then the anti-SLAPP immunity is irrelevant because you cannot protect defamatory statements. Anti-SLAPP is to protect free speech generally and other types of participation like filing lawsuits and things like that. But it can't be protected speech if the statement's not true. So when we talk about like the Ethan Klein and Ryan Kavanaugh case, we go constantly back to, but what was the statement that was made? And what was the statement and what was the statement based off of? And is the statement true? And in that case, it's like, well, Variety said this. Okay, did Variety say that? They did? Okay. So Variety said that. That's a context where anti-SLAPP comes in. I said Variety said this. Variety, in fact, said this. What I've said is true. Here, you're going to have a jury trying to decide what is true and what is not true, and what is a factual statement and what is not a factual statement. So if the jury determines that the statements made by Amber Heard are not true, then this is irrelevant. If the jury decides, as this goes to trial, that statements made by Amber Heard are in fact true and protected, then she can be granted anti-SLAPP immunity, which matters because it can implicate attorney's fees and things like that. So, with that, the motion was unceremoniously denied. And the defense has fought really hard to have this deemed a private matter, not a matter of public interest. And the court, I really would like to know what case the court relied on for that, but they did not tell us. There was another motion of Depp's that was denied on the same day that I have not heard much talk about, but the matter came to be heard same day, March 24th. The matter came to be heard upon counterclaim defendant's motion for summary judgment as to count 2 of defendant and counterclaim plaintiff Amber Heard's counterclaim motion, and upon consideration of the briefs and the arguments, the motion is denied. So I misstated that. This is Heard's motion that was denied. Counterclaim defendant Heard. Wait, no. I hate counterclaims so much. I was right the first time. Counterclaim defendant's motion for summary judgment. Counterclaim defendant is Depp. Made a motion for summary judgment to yeet count 2 of Heard's counterclaim, and that was denied. So the count 2 of Heard's counterclaim is still in and can move forward, which brings me to pulling up Heard's counterclaim to go over what that one is. Because again, not a deep dive, just what happened in court. So let me get to counterclaim number 2 that Depp's team was trying to dismiss on a summary judgment motion. The counterclaim is very long. Oh, let's see. That's count 3. Where is count 2? There's count 2. Defamation per se. So this is count 2 that is still moving forward to trial, even though they brought a motion for summary judgment. It was denied. Defamation and defamation per se. Heard represents and incorporates all this stuff above. The GQ article contains, so this is regarding an article and statements made to GQ by Depp and his attorney. The GQ article contains the following false and defamatory statements and implications concerning Ms. Heard. They are alleging in their counterclaim, Depp falsely alleged that Heard committed a crime by perjuring herself in connection with the 2016 DV restraining order proceedings, stating that there was no truth to Heard's judicial statements of abuse whatsoever. So Depp said that when Heard went to get a DV restraining order, that she lied and perjured herself. And again, if the jury finds that her statements are not true, then they will also find that this counterclaim can't stand because his statements aren't defamatory. The amount of mental gymnastics that this jury is going to have to go through to parse out these counterclaims is going to take some time, because they're going to have to go through all of these statements and decide, okay, well, if she's lying, then this is not defamatory because it's true that she lied. Depp further falsely alleged that Heard fabricated the bruising on her face and otherwise perjured herself in connection with the 2016 DV restraining order by stating, quote, Depp was emphatic about his version of events. Ms. Heard was at a party the next day. Her eye wasn't closed. She had her hair over her eye, but you could see that the eye wasn't shut. 25 feet away from her. How the fuck am I going to hit her? Which, by the way, is the last thing I would have done. And I'm sure the witness list includes people who were there who will come and say whether or not, look, you have a black eye or you don't. Your eye is swollen or it's not. There will be people to be able to testify to this fact or not. They then go on to say that Depp further bolstered his false claim of perjury by alleging that he never committed domestic violence against her, quote, to harm someone you love as some kind of bully. No, I didn't. It couldn't even sound like me. And 25 feet away from her, how the fuck am I going to hit her? Which, by the way, is the last thing I would have done. So they're saying that those statements are false and defamatory because they are calling her a liar. The jury might just be like, look, all of this is so out there, none of you have damages, because that's part of defamation too. Did Amber Heard suffer reputational damage because of these statements? These allegations and implications in the GQ article are demonstrably false and constitute defamation in claiming, implying, and insinuating. Let's see. Even the GQ journalist recognized the reputational harm and damage that would be caused by Depp's allegations in his article, stating, keep reading, Emily, to suggest that a woman might have made up such a serious allegation is a tremendously dangerous and damaging thing to do. Well, so is faking a hate crime. Somebody here is not telling the truth. A jury's going to have to decide who. On April 12th, 2019, Depp, through Waldman, lawyer, is quoted by Page Six accusing Heard of committing defamation, perjury, and filing and receiving a fraudulent temporary restraining order demand with the court, falsely accusing Heard of not being attacked by Depp in 2019. So these are the GQ defamation statements, and they're going through all of the different defamation statements. So that's count 2 that is going to move forward to the jury. So everything's just going to come in. And honestly, I know there are some that are frustrated that Depp lost these motions. Like, my personal gut opinion is that all of it just needs to come in. Like, at this point, this has been going on with these two making statements about each other. It's just all going to continue to play out, and it is all going to get out there. And there are going to be the court-approved cameras in the courtroom. Well, camera in the courtroom. So this is going to be streaming for everyone to watch. So the jury's going to get to make up their own mind, but so is everyone else. They're going to get to see the evidence for themselves play out in court. So maybe letting everything out, all of it come in, is just the better option for both of them. Also know that the standard for the things that are being alleged, the abuse that's being alleged, the criminal standard is different than the civil standard. And the civil standard is different here. So with that, it is a lower standard, but it's all just going to come out. And again, I think maybe that will bring some resolution. And instead of some people saying, well, the court threw out this case, or the court threw out this claim or that claim, the court's like, it's coming in. And people will get to decide for themselves. But the jury will get to decide, and the jury will get to judge credibility, and the jury will get to judge all of the circumstance, because credibility is going to be a huge issue in this trial, which for both parties, credibility is going to be the biggest part of this trial. And who the jury believes. If the jury believes him, then her statements can be defamatory. If the jury believes her, then his statements against her can be defamatory. So all of it's going to come in. And maybe that's just better. Let's look at the motion for sanctions real quick that was just filed. Let's see. What's interesting, why is this not pulling up right? Let me pull it up one more time. All right, let's look at the motion for sanctions. And if, Miguelina, if you'll just timestamp this one too, so we have it as we've moved into the motion for sanctions, because this is a newer one. This was just filed on the 22nd. It's the 25th. What day is it today? Plaintiff John Depp II. We're just going to go with Johnny Depp. We're going with professionally known as. Motion for sanctions for failure to comply with the November 8th, 2021 order. Depp, by and through his undersigned counsel, hereby moves the court to sanction Heard for her failure to comply with the November 8th order regarding forensic imaging. Counsel for plaintiff hereby certifies that they have in good faith conferred with opposing counsel in an effort to resolve the dispute. So let's see what this is over. Let's talk about forensic imaging real quick. Introduction. In recognition of the fact that the authenticity and integrity of the photographs that Heard relies on in this action is at issue, this court ordered Heard to produce her devices for a forensic imaging and analysis of the specified extracted data. So they want the source of the photos. The court order imposed common sense limitations to protect Heard's privacy and data, which Heard and her experts have exploited to the point that the contemplated analysis by Depp's forensic expert likely cannot be completed in advance of the upcoming jury trial of this action commencing on April 11th. Oh, I don't like that at all. Yeah, I don't like that at all. Since the court entered the order in November 2021, the imaging extraction and review process has been plagued by delays and technical snafus, which are at best negligent, at worst intentional stonewalling designed to thwart, we love thwart the very forensic analysis ordered by this court. The result, Mr. Depp has incurred extensive costs, both from his expert and the court-appointed limited discovery issue conciliator for nothing. Depp's forensic expert, Brian Neumeister, has not been able to review, let alone analyze, the authenticity and integrity of the photographs Heard relies upon to support her claims of abuse. Though he should get a continuance, this order gave enough time. Okay, keep reading, Emily. Keep reading. In a case where there are he said, she said claims of domestic abuse, the prejudice to Depp in not being able to test the authenticity of this key evidence cannot be overstated. There must be consequences. I mean, you've had since November 2021. The fuckery. Like, that's simple. Look, this is happening. Playing, hide the ball with discovery is just disingenuous. I don't like playing games with this kind of shit. It's like, look, just me. I'm not going to soliloquy anymore. Also me. Yep, I'm not done yet. This type of hide the ball is just gross. And I realize it's one of the things I do not like at all about civil litigation. In criminal proceedings, there are a whole lot of rules. And it's just like, here's all the shit. Here you go. We're not playing hide the ball. You did it. You didn't do it. We can prove it. We can't prove it. It's very clear cut. The hiding of evidence and the hiding of an examination is since November 2021. Like, come the fuck on. If you stand by your claims, then turn over the phone. Jussie Smollett, if you stand by what you're saying, let them analyze your phone. What do you have to hide? Y'all are right. We should just code red. I mean, the hiding the ball really pisses me off. It's fuckery. You're right. You are right, law nerds. I have code redded myself because I am annoyed by this. So, a brief warning. For those of you that are flash sensitive, I very much love our bumper to go to DEF CON WTF, because seriously, WTF, you are ordered to turn something over, turn it over. But it is flashy. Once the music is done, the flashy will stop. But it is flashy. So We are going to DEF CON red in 3, 2, 1. Red. We're red. Well, some of those still wanted to be pink, but I feel like we're red. Red enough. I don't like it. And even if they don't get the sanctions, I wonder what comes next, because this is not going to be done. All right, let's finish reading this. Let's finish reading this while the rage happens. And it said the court order, I'm going to have to pull this court order. I'm going to have to go back and find it. The court order imposed common sense limitations to protect Heard's privacy and data. Fine. They want to examine the photos, these photos, what if there's videos, those videos. Let's see. There must be, we ended on there must be consequences. On November 8th, 2021, the court ordered a forensic imaging of Heard's devices so that Depp's forensic expert could analyze the integrity of the photographs Heard had taken during specific time periods during which she claimed abuse by Depp. That makes sense as part of discovery. And all of you that have been hanging around talking about the Duggar case, we've talked about imaging a little bit because you image the thing so you can do the forensic analysis of the thing. So you make a direct copy and then do the analysis from there. They can limit what they copy. She's also suing. So, you've got to substantiate your claims too, boo. Pursuant to the order, the forensic imaging would be conducted by Heard's I'm annoyed. That's why this is so hard. Pursuant to the order, the forensic imaging, meaning the copying from Heard's device, the forensic imaging would be conducted by Heard's forensic experts under the supervision of the expert of Johnny Depp or his colleague by November 30, 2021. We're not close to that at all. Because the hardware and software used to conduct the imaging and extraction of data is critical to ensuring the integrity of the data for purposes of the analysis, the order provided that should Heard's experts not have access to the appropriate hardware software, that the expert for Depp would make arrangement with Heard's experts to ensure the appropriate programs are used. It matters. It matters. It matters. To protect Heard's personal and potentially privileged data, emails with lawyers and things, the order provided that a neutral third-party attorney, Craig Young, would review the extracted data and isolate any irrelevant or privileged information from the data set to be analyzed by Depp's expert at Depp's expense. Well, that's indelibly reasonable. Also, all of this is going to take a lot of time. This is reasonable. This is time consuming. Unfortunately, as of February 18th, 2022, the imaging of Heard's devices and cloud accounts still has not been completed. Oh, fuck. This trial might not happen. And Depp's expert had not received a single piece of extracted datum. Wait, is datum the plural of data? You don't just say datas. Data is datum a plural of data? I have learned. Look, we've learned new things today. Mr. Depp's expert has not received a single piece of extracted datum to analyze. In fact, the expert did not receive any extracted data until March 2nd, 2022. That's like a month before trial. Okay. Oh, you guys are correcting me. Datum is the singular, data is the plural. Thank you all. Launer, I will re-engage with the grammatical. Datum is the singular, data is the plural. Appreciate it. See, we learn new things. Is grammar your strong suit? I'm like, no. No. All right. Date extractus. So datum would be the singular pixel of a picture. So did not receive any extracted data until March 2nd, 2022, and to date is still receiving data extracted from Herd's devices on a rolling basis. Even when data is finally available to send to the expert, there are inexcusable mishaps and delays, and on one occasion, an encrypted drive of photographs was sent to the expert without the password necessary to access the contents, so the drive needed to be resent. On another occasion, the expert received a file without the raw photographs, not in the agreed upon format. Making matters worse, much of the data has been provided to the expert to date are either irrelevant or seem to be corrupted. That's not good. That's not good. You know, okay, keep reading, Emily. Keep reading. Just keep reading. I'm glad we're red. I'm so glad we're red. I'm glad we saved this for the end of the night. I'm disappointed that I didn't pour a whiskey. Of the over 58,000 photographs the expert has now received, a substantial portion of these are not the types of photographs ordered to be analyzed, namely pictures of Herd. Many of the other photographs are essentially incapable of analysis. For example, there are multiple photographs that are visually the same and indicate that they are directly photographed image, but these original photos do not hash, with the hash being the digital fingerprint of the photograph. So are there no hash file? For other photographs, the EXIF data shows dates from the 1970s or the 1980s, which is literally impossible since EXIF data was not invented until more than 20 years later, and Miss Herd was not born until, we've redacted her date of birth? Okay. The EXIF errors were not the result of the photos being extracted from unallocated space, as they revert to epoch time in the EXIF data in most every case. Thus, these anomalies may be the result of the unlicensed and outdated software used by Herd's experts to image her devices. So the imaging is not being done properly, is what they're alleging. That when you image the drive, that it is not being made a duplicate exact image copy to the standards that it can be used for forensic analysis. Oh, no, I don't like any of this. This is pissing me off. He said he would pay for the software. Like he said he would pay for me now, just I'm so annoyed. Okay. Ideally, Herd's experts would have used licensed up-to-date software, the Shade, to ensure a clean image and extraction. Do they want clean imaging extraction? Do they want clean image? Do they want it? Do they want it? But unfortunately, the forensic images were extracted before the team learned that Herd's experts were using unlicensed software. This is going to create a mess. In short, the process has been a mess. Keep reading, Emily. Keep reading. Keep reading, Emily. Keep reading. In short, the process has been a mess, and the data obtained therefrom is unusable for the purposes of analysis, or of the analysis, that the expert was hired to perform. Argument. WTF. This, again, is the motion for sanctions because of the fuckery. This is not a motion to make them comply properly. This is a motion for fuck you. you should be sanctioned, but a motion for sanction is also making the court aware of this. The trial court has broad discretion to fashion an appropriate sanction, which can include financial sanctions. Here, Heard and her retained experts are in blatant and inexcusable contempt of this court's order directing the forensic imaging of the devices. Regardless of whether this contempt is the result of sheer incompetence or intentional conduct, sanctions are warranted. Although this court need not find that Heard's failure to obtain the order has caused Mr. Depp prejudice to award sanctions, Depp's prejudice is undeniable, and accordingly, sanctions are all the more necessary to right the wrong. Mr. Depp has, at great expense, retained a forensic expert, foot the bill for a neutral third-party attorney, which, as of the first invoice Mr. Depp has received from Mr. Young, totals $40,000 to review the extracted data and thereby protect Heard's personal privileged data, all in order to vet the evidence, which is the centerpiece of Heard's case. Toss it out. Photographs purporting to show injuries caused by Mr. Depp, and because of Ms. Heard's unconscionable disregard for this court's order, all of this may be for naught, as time has essentially run out for a competent imaging, extraction, and analysis to be conducted before trial. Mr. Depp accordingly requests the court to impose the following sanctions on Ms. Heard. Order Heard to reimburse Depp for the cost of A, his retainer of the expert, and B, the court-appointed limited discovery issue the conciliary, we're going with that, Mr. Young, and 2, order that all photographs of purported injuries that Heard intends to rely on at trial, as reflected on her exhibit list filed March 14th, are inadmissible for any purpose. Yeet the photos. Yeet the photos. None of this says delay the trial, by the way. Alternatively, instruct the jury that they may infer that any photographs of purported injuries that Heard offers are admitted at trial have been manipulated or altered to show injuries that are not present. Because if they can extract it, they can show if Facetune was used. They can show if the photos were in some way manipulated. Exhibit A. Oh, this is their proposed order. Oh, no, this is the order from the court. Okay. This is not their proposed order. This is the court's order. Let's see. Upon consideration of plaintiff and counterclaim defendant Depp's motion to compel defendant and counterclaim plaintiff Heard's production of original devices and operating system drives and cloud backups of the original devices as requested in plaintiff's 7th set of requests for production and Heard's cross motion to compel Depp to produce forensic evidence for sanctions, the opposition's thereto, arguments for counsel, and being fully advised, it is this 8th day of November ordered that defendant's motion is denied, so Heard's motion is denied, except Mr. Depp shall produce any native files with metadata of photographs reflecting injuries and audio and video recordings of Mr. Depp and Ms. Heard that are in Depp's possession that have been previously produced in discovery without metadata. Plaintiff's motion is granted in part and denied in part. Defendant Heard shall produce her original devices, including mobile devices and computers, including laptops and iPads, as well as operating system drives and cloud backups of those original devices for purposes of performing a physical imaging of all data from the original devices as requested in plaintiff's 7th set of requests for production for purposes of clarification. For purposes of clarification, Heard's original devices shall include all devices on which the data was taken or originated or have been maintained. So literally everything. And then it goes through how it will be imaged. For computers, a write block raw DD non-segmented forensic image. For mobile devices, Heard shall provide the passwords for the devices she used during the relevant time period so data can be accessed, and the check M8 check extraction, I can't read the rest of that word, shall be performed where possible for each cell phone. For the cloud accounts, Ms. Heard shall provide the username and passwords. And they named the programs they wanted to use. So if they're not using those programs, I wonder what they're using, because this order names the programs to be used specifically. If Heard's designated forensic experts do not have access to the hardware or software required, Depp's expert will make arrangements with Heard's expert in an event that a dispute arises between the experts. The court-appointed conciliary shall resolve the dispute. And then they have the time periods to be searched, limited down, the dates of the photographs, how the extraction is going to happen. It's a really, really thorough, narrowly tailored order. And then the declaration of the expert saying all of what's up above. That the court-ordered deadline was November 30th. To date, some forensic imaging has occurred, but no photographs have been produced. There was a deadline of November 30th. This is going to just get worse. Let's see what else. The rest of the declaration about doing the forensics. And then all of the forensic experts, experty shit, and all of their experty stuff. Okay, Brian at usaforensic.com. The thing is, though, there's a court order ruling on the motion for sanctions. And I want to make sure it's this motion for sanctions. So we're going to do that right now. Let us pull that up. Why is this not pulling up? We have one more thing. And then we're getting to questions. Because there's a court order. Where is it? Let's see. This is a different one. Just wanted to make sure. So this is a different motion for sanctions. Because that motion for sanctions was just filed on the 23rd, I think. Let me go look real quick before I pull this one up. Just to be precise, my brain has started working tremendously more slowly. More slowly. Let's see. Depp's motion for sanctions was filed on, March 22nd. So this is filed March 22nd. The court ruling is a different motion for sanctions. And this was heard on the 23rd. So this matter came to be heard upon plaintiff and counterclaim defendants' motion for sanctions filed on March 11th. And defendant and counterclaim plaintiff Heard's cross motion for sanctions filed March 11th. Everybody was filing for sanctions in March. And upon consideration, it's ordered that the motions all be denied. The court's like, stop it. Stop it, all of you. However, the issue of the forensic imaging is a big deal. This is a big deal. I'm surprised it's gone this long before coming up before the court. I'm not surprised it's coming up on a motion for sanctions. The court's going to have to address this quickly. I mean, we are very close in time to this going to trial. And I wonder what happens if the court yeets the photos. If I were the judge in this case, I would be so fucking angry that I ordered a deadline in November. And this may have come up before. I've been going through the extensive record in this case, but I have not. This is the first time seeing this come up. It doesn't mean it hasn't come up. I just haven't seen it yet, which is why there will be a deep dive in like a week and a half. But if this is the first time this is coming to the court's notice, like this was due at the end of November. And I get it with holidays that maybe they don't bring it to the court's attention, but we're now weeks away from trial and this is not resolved. And I don't know what remedy Depp has other than get rid of the photographs and none of Amber Heard's photos can come in, or push the trial date. I don't know what else you do. You don't fix that. And you've got to fix it before the shit's out of the horse. And once it goes to trial, the shit's out of the horse. So you have to remedy it, because this is a valid and thorough and narrowly tailored court order for a reasonable purpose. And I think the court has every right to say, fine, you can't use any photos. If you want to play these games, You can't use any photos. I'm going to be very interested to see Heard's response to this, which will probably come early next week. There is a lot of litigation to come in this case before it goes to trial on April 11th. So there's a long way to go and a short time to get there. And the thing is that these lawyers are going to be working overtime, but the rage over over the fuckery of the photos, the fact that the forensic examiner has gotten some shit, but not the actual shit that they asked for, not 58,000 photos, but not the photos that they've asked for. It's just unacceptable. It's just unacceptable. These kinds of games don't go well, I don't think, for a party. And let's see what the court does. I'm in favor of the court right now saying, I gave you timelines. You did not tell me why you couldn't adhere to the timeline. Again, Heard's team still has an opportunity to reply to this, and we will hear what they say. But based on this, yeet the photos. Yeet the photos or delay the trial. I think those are the only two options, and maybe grant sanctions. But this is not a good look, and it feels like fuckery to me. So we're going to be talking a lot more about this on the content coming up. So this we are just beginning. I know a lot of you have been asking me to cover this case for a long time, but there was no real good entry point because there is so much litigation here. So now we're getting ready for trial. We're just like we're just jumping in with both feet, and I will be covering it. I will be covering the trial. I will, if I can stream some of it, I will be streaming it. If not, I will be watching it and reacting to it. I think we should be able to stream it on the YouTubes and do commentary like we've done for other trials. I know that Legal Bites will be streaming it over on her channel. She's also covering this on her channel. So if you have not checked out Legal Bites' channel, check it out. She broke down the last motion for summary judgment before this ruling came out. If you want a full breakdown before I get to it next week, it's over on her channel. And I'll be covering it. I mean, I do have a live event April 13th here in Nashville with hashtag no filter sack and Up and Adam. So there will be some days I won't be covering it. Jury selection should take a little bit of time, but wow, we're going to get almost daily litigation, I suspect, in this case between now and April 11th. But I really want to know what the court does with this one, because I would be pissed. All right, enough of me. Oh my God, 2 hours and 30 minutes. Thank you, mods. We need to get to some questions and some super chat. Also, if you're not subscribed yet, we should be binging. We should be binging. We were very close. So if you are not subscribed, go ahead and do the likey, subscribey things. I would appreciate it. We might get the yeeted questions. I am going to go back through and look not just at the super chats, but also the questions. I had tagged some while we were going through. And let me see. There was a question I was looking for because I saved it from earlier. Cassidy Christine asked, Emily, can I ask what your Enneagram number is if you know it? Much love from Kansas City. All of you, how many of you in the chat are fans of the Enneagram? I'm a fan. I love a personality test. I do. I'm a fan of the Enneagram. Let me know in the chat if you're Enneagram fans. And if you would like to share your Enneagram number, you are invited to. It is a safe space, but you do not have to. You will not be surprised that, or maybe you will, maybe you won't. You will not be surprised that I am an Enneagram 1. I am very much an Enneagram 1. I am an Enneagram 1. I'm a 1. I am a 1. I'm a 1. And I am a very one-y 1. I think my oldest is also a 1, though sometimes he has some very 8 tendencies. So we will see. I want someone to create like an Enneagramming the Housewives. I have wanted to do it where people look at the Housewives and sign them. I know that's not how it works, but I would love it because I'm an Enneagram fan. So I love that you guys are sharing your Myers-Briggs. INFJ. Isn't INFJ the more rare one? I'm an EN something. But I need to redo it because I think I am not fully an extrovert. I think I am omniverted. Somebody asked if I had, and you guys are welcome to share your Myers-Briggs. You're welcome to share your human design. You're welcome to share any of the things that you would like to share. I love a good personality assessment. So, Ashley said INFP is the rarest. Thank you, Ashley. I have a J in mine somewhere. The Foxy Project's like, I am a Ravenclaw. I think Travis and Dr. B are definitely Ravenclaws. I think I'm a Hufflepuff. I really am. And I maybe hate this about myself, but it's kind of true. So I love it. Okay, you guys all chat. I love that we're here having this chat about the Enneagram. So I had pulled that question earlier because I absolutely wanted to make sure that I got to it. I want to get to a few questions for sure. Question: the Sun's lawyer said that Amber lost the Aquaman role. They asked JD if he had anything to do with it / the petition to fire her, which was part of the counterclaim. Does it still stand? The counterclaim is moving forward. They only moved against claim 2. I don't know if Amber Heard lost her Aquaman role. And so I will have, as I get into a deep dive, I will keep that in mind. I have not seen anything that part of the counterclaim has been needed, but it might have been. So if he had anything to do with it, I can understand what would be there. When you're already in litigation, I don't know, but did Amber Heard really lose her role? I don't know if she did. So anyway, that's what it is. Spamachu said, I'm a Slitherpuff. Slytherin with Hufflepuff tendencies. My youngest identifies as Slytherin. She was so she was fired and then rehired. All right. Emma, thank you. I will keep it in mind as I go through the deep dive because off the top of my head, I cannot tell you. So I will keep it in mind. There has been lots of firings over this. I do know that. So we will. I love this. So let us continue. I've got to continue. K. Rob said, your title is misleading. My title of the video is not misleading. Johnny Depp did not lose in court. Yes, he did. His motion to dismiss her counterclaim was denied. It still goes to court in a few weeks. Yeah, that's a loss. He lost his motion to dismiss. Still a loss. So potato to potato. I think it's a loss in court. I am going to call it a loss in court for all of the YouTube-y things. Natalie Lawyer Chick called your channel a public service today on a live. I thought it was so sweet. I also think her channel is a public service. I think it should be mandatory viewing. I adore the ladies of LawTube. I am a huge fan. I think Natalie's great. We all need to the ladies of LawTube all need to get together and have a panel again. I need to chat with everyone. I want to chat about this. I want to chat more about Jussie. I want to chat. Emily D. Baker over the new season of Bridgerton. That is Dawn. That is probably the nicest thing anyone has ever said to me. Thank you so much. The struggle today to not just binge watch Bridgerton was real and was difficult, and it pervasively popped into my brain during the entirety of my workday today. But I had to have calls. I had multiple meetings today. I feel like such a douchey YouTuber when I say that. It's like I had meetings today, but did. And have to prep the podcast, which I was supposed to record today and then couldn't because my brain stopped. So podcast is getting recorded tomorrow, and then prepping this podcast to get recorded next week. So it's just like the life of a content creator. So I didn't get to binge watch Bridgerton today. I can't binge Bridgerton until I finish this week's podcast. It is not done yet. Jennifer H., did you get my email with the tracking number for a ton of candy I sent you guys? Excited for you to get it. Some M&S and some Aldi stuff. Thank you so much, Jennifer. I will go look for it. I'm not going to say I didn't. It might have come in and I might not have seen it. My team might have already checked on it. And I am doing a mail run this weekend because it's been too long. So Sarah said, suggestion, could you put the times you explain things like latches, estoppel, etc. So when I forget, I can go reference and you don't have to re-explain everything. Love you. Thank you, Sarah. I intend, this is an intend. I intend to start pulling some of those onto the Quick Bits channel so they have somewhere to live when I pull them out. Like, what is an anti-slap? Here's a 3-minute video on that. So that is my intention as I start pulling things for the Quick Bits channel. So thank you for that comment. Yes and yes. Plan Your Spoon said on Facebook, I'm in a Facebook group called Creative Exchange, ADHD style for trading craft supplies that you... Oh, I'm not on Facebook much, but that is a brilliant idea. Plan Your Spoons. Thank you for sharing it. So everyone in the chat who's also like, this is brilliant. I love that there's a Facebook group because of course there is. Brilliant. JC, not me over here accidentally skewering your demographics because I forgot to switch my NORD back to US server. It's okay, JC. You can NORD in from wherever you like. It is fine. Openly avoidant. I love that name. Me. The avoidance is real. Shout out to Emily D. Baker gaining 200K like a boss. Thank you. Happy Friday. Hope you all have a wonderful weekend. Woohoo! Love to see it. I love to see it too. I can't wait to see it hit 2001 because soon we're probably going to bing sometime in the middle of the night and then I'm going to be like, damn it. Oh, wow. Paige said, my kitten seems to like watching the chat and brought up a super chat. She really said, here you go from the Paw Nerds. Paige, I love that. Thank you to your Paw Nerd from my now sleepy Paw Nerd. Like Fred had his moment in the sun and went back to the chair that I bought so I could sit and read in that has now just been taken over by Fred and George. This is their space. And when the blanket's like up there and I don't have it on the seat because I've been in the seat, they will like pull the blanket back down. They will make it happen. Bobbit, thank you for the moderator love. Much appreciated. I used to work for a large bank that has the word America in it, and they had a marketing strategy called TSU Catch the Wave. Interesting, Jessica. Thank you for sharing. That from the back, that was when we were talking about Wendy Williams, I'm sure. Catnip tip to encourage Fred photo posing. I'm posting Fred on Instagram after this. Cue up the Spinners song, games people play. Thank you, Catherine. Samantha said, question, why haven't the kids been charged in the college admission scandal? It seems like some of the kids participated, like Olivia Jade, because in the federal bribery case, from everything that I've seen, the kids, though they might have participated with posing, the kids didn't do the wire fraud. So the wire fraud didn't happen. So, yes. Making a motion for orange lights to be declared DEFCON Fred. Ooh, motion granted. Fred fuckery's getting its own color of lights. You hear that, Fred? When you start banging around my camera, you're getting your own color. We love DEFCON Fred. Yes, motion granted. My gavels are back there. I've granted it. I've got words, just graduated with a BA, endlessly fascinated learning about the legal system. Are there any entry-level jobs I could look into without any previous legal experience? Training program, paralegal, maybe. Paralegal programs, yes. A lot of law firms will hire people in and train them, especially depending on what your background is. If your background's in writing, a lot of firms will help people become legal secretaries. I don't know if there are training programs for legal secretaries as well, but there are lots of ways to engage with the law. The problem is when you engage with the law, you also have to engage with lawyers. And I am not like most lawyers. Do not base me or lawyers off of me. Most lawyers are not personable. Some are, not all. You missed all the Fred jokes, the Fred Pokemon jokes. I mean, I definitely chose him, but I need to like... So, Sarah Smith, why do guardianships even exist? Even if Wendy wants to blow her money, why isn't that her right? Sarah, this I think is a very much deeper conversation, but here's what I will say. There are absolutely circumstances where guardianships are needed. There are circumstances where someone does in fact have something like dementia and a power of attorney was never signed, but they actually can't make medical decisions. And the only legal way to have somebody in charge of their medical care is to put them under a guardianship or conservatorship to make those medical decisions. This can also happen with adults with different types of developmental disabilities where they are not able to care for themselves in an independent living way, but they have reach the age of 18 and are legally adults, so that a conservatorship or a guardianship can be the appropriate mechanism there. So with regard, Wendy Williams aside, there are absolutely legal reasons why these things exist. They are meant to protect individuals who are unable to self-care or vulnerable, like the circumstances I just described. If Wendy wants to blow her money, why isn't that her right? It is absolutely her right, but it seems like the bank, based on their filings in court, not saying that I agree, believes that there is undue influence there. And if there is undue influence there by somebody trying to manipulate her to do something with her money, they have the right to step in some capacity. I don't know if asking for a guardianship is the right capacity. So, yep. So that. Let's see. Most lawyers are not personable. It's true. Emily has lime green nails, so I'm going to paint my nails lime green. This is inspo from the newest Holo Taco Cremes, because that is the color I put on my toes. So this is absolutely a Holo Taco inspired manicure, and it is getting revised on Monday, and I cannot wait. So, Amy, thank you for sharing. I have a paralegal degree. I've seen many paralegal jobs that require a bachelor's in no said field. So there you go. Just graduated with a BA, and there you go. Many paralegal jobs that just require a bachelor's. Thank you, Amy. See? Law nerds helping law nerds. I love it. I'm going to do a few more questions, and then I'm going to have to go because now I'm getting hungry, and I want a hot chocolate with Bailey's. It's still living in the back of my mind. I am highly susceptible. I have to tell you guys a story in just a second. Taylor Davis said, Emily, I started watching you over a year ago because my husband was going into law school. He is now finishing 1L, and I sometimes know something he hasn't been taught yet. Get it? You're going to learn all the things. And when your husband comes home and is like, oh my God, and the chattel is the nose, you're going to be like, the chattel's not the nose, the chattel is the dog. It's going to be fantastic. Susie said, Emily, we need a code Fred complete with video. I have a suggestion for the video. Hold on. This happened on and then I have a story to tell you. I'm going to totally forget. I'm going to try not to forget. Damn it. My brain just went. I don't remember what I was talking about when I said I have a story. And I totally forgot. Wonderful. Okay. I was going to show you what video I was thinking of. Let me see. Unfortunately, on the GIF keyboard. Okay, so here's what I'm thinking for Code Fred. This GIF was made by the lovely folks at vidIQ when Fred smacked me in the face with his tail. I need to find the better clip of that, and that is going to have to be the DEF CON Fred. That is going to have to be the DEF CON Fred level, because that happened during a vidIQ live stream. And then they made it into a GIF that lives on the GIF keyboard. I don't even know how you put things on the GIF keyboard. Somebody figured out it's on the GIF keyboard now. So I think that's Fred's video. Because I got like all of these. So anyway. Fourth phase, are you talking about me? I'm a Virgo rising. I love my chat. A question. Why wasn't Wendy allowed to use her own doctors as a defense? Bunny, we don't know if she hasn't been. We're not even there yet, and we can't see the court records. So all we know is what we're in the initial question or the initial filings. And so she is in the process with a court investigator over in the guardianship. We know a court investigator has been appointed, and that's where a doctor that she meets with will work in there. So we're not done yet. Like no guardianship's been appointed yet. They're still in that process. So she will be able to do that and does have a lawyer. Cynthia, question, why the flyby on Nick's channel? Oh, I was prepping work and he was live and I wanted to see what he was talking about. So I popped by to see what he was talking about. So, because Nick feisty as he can be, I wanted to see if he was talking. I think was he talking about the Supreme Court? He ended up talking about getting swatted, and he had shared that in our group, the lawyer chat, which is crazy. But I had popped in as he was telling that story and just had to make a comment that he's absolutely famous now. So I was talking about hot chocolate and Bailey's. I don't remember what I was going to say. I totally forgot. Pocket Angie Tips, so good to see you. Can the fandom file a class action suit against Amber Heard for ruining Fantastic Beasts and Pirates if he wins his case? I feel like that's a completely reasonable decision because, yeah, I'm really bummed that he's not going to be in the Dumbledore film and Pirates. I mean, I won't file it, but I'll allow it. I think it's a very reasonable urge and desire. So we will see what happens with this case. Question, any chance of a follow-up Toddy discussion live stream over on Jen Loves? That's how I found this channel and your amazing personality. I have not, I need to touch base with Jen. I don't know if there is any follow-up to be had, but if there is, I'm always down for a conversation. Janelle said, love Lady Justice holding the scales behind you. That was a gift from my grandfather when I graduated from law school. So thank you. I love her too. She has been in all of my offices. She's very sassy. She also has particularly large feet, which is something I noticed when I got her as a gift. I don't think my grandfather noticed that, but I have very large feet. I mean, not as large as my brother, who wears like a 15 or something fucking ridiculous, but huge feet. So I love it too. Any Tati updates? Will her move to Texas not affect her lawsuits? I have not really thought about whether her move will affect her lawsuits. I mean, there's still the Washington lawsuit. I don't think it'll change jurisdiction, but I haven't really thought it through. The Washington lawsuits should all probably be in Nevada anyway, is generally my feeling. And the Nevada is the proper place for all the Halo Beauty stuff because that's where they are. So we will see. We will see. So the creator of the GIF just died this week. I didn't know that. Because of his death, there was a comment he made attached to his death announcement. He says correct pronunciation is soft G or GIF. Kira, I'm going to have to look that up, but thank you. I appreciate it. Susie said, I'm a Virgo with Virgo rising, hard not to be critical. I mean, I'm a Taurus sun, Taurus moon, and Virgo rising. It's a whole lot of earth signs over here. But I love all of the things. The Enneagram, the Myers-Briggs. I love all of the things. I love all of the self-explanatory stuff. I love all of it. All. All right, I'm going to keep looking at a few more questions and then, again, going to bounce. I love the conversation you guys are having. When will we see Galaxy Hair? Soon. I need to make an appointment. Scheduling things is hard. It's been a week with scheduling things. Large feet for sturdy standing as symbolism. I mean, yes, I definitely have good balance. And when when I went to look for so if you guys follow me on Instagram, you will have seen my bright neon pink Adidas that I am in love with. The only reason I didn't realize the Ivy Park Adidas collab was dropping, and the only reason those weren't sold out is because of the extended sizing of the shoes. So they weren't sold out. All of the other sizes were sold out. I was very excited. So I've known like 10 Virgos and none are alike at all. I mean, that tracks. That does track. Catnip tip, thank you. Simply because I love you in this community. Love you too, Ashley. I'll use the rest of this space to encourage all to learn about sarcoma. It is a hidden and forgotten cancer. Thank you, Ashley. I appreciate that. Let's see. I love you guys. I love how much you guys are sharing. It's so fun. Angie said, question, how do you find out what moon you are and what is rising? Oh, Angie, get ready. Get ready to go on a journey. The chat, I'm sure, will tell you. I like the Channy app. Chani. She's also on Instagram. She has a very easy and accessible to use app with a lot of details. So if you're ready to go on like a deep dive into all the things, deep dive. I love it. Question from Paige. How is Wendy's old doctor not breaking HIPAA? I don't know. It's a very good question because it feels like a problem. And when I covered that, the reason I said, unless there was something signed, and that is the issue. So the circumstance is so challenging for me to wrap my head around because it's just, there's something very not right about a doctor sharing that kind of information with a banker in any circumstance, unless it had been previously signed that release was okay. But the way Wendy talked about it doesn't seem like she thinks that release was okay. So there are definitely questions there, but I'm not willing to say this is absolutely a breach of HIPAA because I don't know if there is something signed. If there is nothing signed, it's absolutely a HIPAA violation. A doctor can't disclose medical information without authorization to a third party. That is exactly what that's for. So if there is nothing signed, then yes, it is a problem. Hopefully that was clear. Clear as mud. Fred's spirit guide is Drop Dead Fred. The shenanigans are wonderful. I think so. I mean, between that and the Weasleys he is named for, yes. So all the things. Bop it. Everyone belongs here. So question. My new law teachers keep saying the only thing overseas lawyers know about New Zealand is ACC. Do people actually know about it? I have never paid attention to international law much. I'm sorry. Some might, I don't. So some might, I don't. I covered this early on in the stream, but we can do a deep dive on it later because we definitely didn't. So could Jen Shah's tagline be used against her at sentencing? I mean, it could come up in a sentencing memo that she never took any of this seriously, but so much of what went on could. So much. Mother Oats, this is a great question. Is there a difference between Ventura County and Stanley Moss Courthouse? BJ, that surprise, said it was night and day difference on how the court officers treated her. Yes, there is. So I used to work in Stanley Mosque for a while, but Stanley Mosque is LA County. Stanley Mosque also deals with a high percentage of celebrity cases. And Ventura County courthouses are a different county. They tend to be a little bit lower volume. Stanley Mosque is a very, very high volume case. A lot of the court staff is kind of burnt on celebrity cases. When I worked there, kind of burnt on celebrity cases, and it's a lot. The Britney case is a lot. So I'm not surprised it's different. I'm also not surprised it's different after the audio recording leaks. The judge that was in charge of the Britney case was so pissed about it. So I'm not surprised it's night and day. They are completely different courthouses. They deal with different volume. And yes, they're in different counties. So the system operates differently. Let's see. Question. My son graduates from UCLA this year. What's one thing you recommend he has to do at UCLA or in the area? Go to D.D. Reese. You have to go to D.D. Reese. But he probably knows that and has probably been to D.D. Reese. You need to go visit and go to D.D. Reese. Emily, why is the first thing you recommend food? I don't know, because those cookies are amazing and I still think about them. They also hold a warm and special place in my heart because my husband spent so many years at UCLA. And so many years while we were dating that a lot of our date nights were me driving up to UCLA because he was still at work, us going out to dinner, and then me going home and him going back into the lab. So I have lots of fond memories of UCLA. Go to a water polo game. They're a lot of fun. And I mean, UCLA is great. There's lots of great stuff around it. So D.D. Reese is always top list, but that's probably already happened. Let's see. I'm going to get to just a few more. Whoever said built-in flippers, yes, I always saw them that way too on my feet. I did. I finally saw the video of the lawyer with the cat filter, and now I understand lawyer cat. Fantastic. I need to add lawyer cat back to this computer. I haven't had a chance to do it yet. Fawn Whisperer said, Emily, nothing soothes my ADHD like watercolor painting. It requires short bursts of focus and teaches you to make beautiful what you can't control. I love that. I've always been fascinated by watercolor. Always, always, always. So anyway. All right. I am going to have to say goodnight. I'm just reading the chat because now I'm like, let's just continue to chat. I am so hungry. It is time to go. It is time to go. But I've shared all the things with you. Like and subscribe. If you have not, you can see on my channel where my new channels are. I've told you kind of my intention with what we're doing with Quick Bits and what we're moving over with Quick Bits. And that will be a slow, it's going to be a rollout process. So from that, it is time for me to say goodnight. I appreciate all of you. We covered a lot of topics tonight. Fridays have been busy, but a lot's going on. I feel like if we don't keep up with it, it's just going to run me over. And then the TikTok thing happened. I probably should have pushed it to Tuesday. But Tuesday, I fully intend to just do an entire Britney stream because there have been a lot of new filings in court. I have been wanting to cover them, and it's nice to just be able to say, okay, we're doing this. We're doing this on Tuesday. So with that, stay hydrated, mind your business. Thank you for being here. Thank you for being a law nerd. Huge love to the moderators. Thank you so much for your time, and it is time to go. Good night. I will see you soon. Bye.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.